This person said about your lovable, wonderful towel. I think I want to play a song while that tweet is up on the screen, because you know what? I was raised in a beautiful country called the United States of America. I want to dedicate this to, let's see, Kate Peter and Tuesday Gazette and Julie Carpenter and Ginny James, and then let's see, any other person on Kate Peters' Discord. Oh, Jason Broyles, he's a weird one. And then, not Biff and Boomer. They're gonna flip. Biff and Boomer flipped. Federal indictments are imminent. But everyone else that is Kate Peters' friend. I have a message to you and your Shrek-based odd cult leader. Okay, ready? Let's do it.
For you and you and you, I hate your friends and they hate me too. I'm through. This that hot girl bummer anthem, turn it up and throw attention. This that hot girl bummer anthem, turn it up and throw attention. This that throw up in your Birkin bag, hook up with some momentum. This that social awkward suicide, that violence, swear she had a liver city to the winner's face. And had that college level music, we did it this. Friends are all annoying. And they hate me too.
Hello! I didn't see you there. Good evening. My name is Grant Smith Ellis. Look at that. We're back! I know, the ruling came down from Judge Gildea right as I went to the doctor. Now listen. If you're wondering, Grant, first of all, did you eat? Yes. I got some bonchon chicken. It was delicious. Okay? It was delicious. I ate some bonchon. And then I had some rice. It was delicious towel rice. Okay, I like chicken. I like rice. What do you want from me? So, see, a lot of people ask me, like, Grant, why do you eat on stream? It's weird. Well, the towel moms, get mad because they know I will stream for 8 hours in a row. They watched me during the war, and I just won't eat. I get so... I have things I want to yell about. Now, listen. I got my bonchon, okay? And while I was getting my bonchon, I was listening to this order. Now, if you're wondering, Grant, did you roll out a special Judge Gildea voice for us? Yes, I did. Hello, T.A. Sarah. We're back. We had a slight frame drop. We're back. It will never be more than 10 seconds. Towel News is very efficient. Now, listen. I got really mad. You're going to get really mad reading this. Now, I want to begin, I want to prep you by saying the way you read a 12b6. Okay, this is in the Higgins Albert McCabe versus Karen Reed and TurtleBoy lawsuit. You read it with the facts in the pleadings in the light most favorable to the plaintiff. So in federal court, that'll be in the light most favorable to Karen. Here, it's in the light most favorable to H.A.M. Keep that in mind. Second, prepare yourself. This is bad. It's bad in a lot of ways. Okay, it's bad about who was working for who, where they were working, etc. It's bad. Everything is bad. The things that got Karen the worst are bad. Very bad. I mean, Karen would not be involved in this lawsuit in terms of her own statements, but for 3 remarks to the documentarian who flipped on her. So I want first of all, just calm. I have a brand new Judge Gildea voice. I know you guys are gonna love it. All right, I made this specially for it's bad. I'm preparing you now because I already listened to it. It's very bad. It's gonna get what is the word? Also, by the way, I don't control the ads on the YouTube. I just start the stream. I have it set to the medium or lowest level possible. It's the amount of people that are interested in the content. YouTube controls the ads. I don't. It helps the channel for you to watch them, skip them after the time. That helps me, but because it retention. But I'm not choosing when the ads run. I promise you. Uncle Alert. That's great. Okay, so you're gonna get made. Okay, you're gonna get very made. I want you to prepare yourself for getting made. I know Attorney Little's gonna talk about this. I didn't even realize, but she will also get made. But let's read it once. You always get more in a second read through. If she is as mad as I am, then something's very wrong. Okay, so let's see if I'm made. I already know I'm gonna get made, and we'll go from there. And I have a special voice for you. Everybody, get ready. Here we go.
Of Massachusetts.
Oh, that's right. You can also get YouTube Premium, which is a great... If you actually watch with YouTube Premium, I found out that that is a great way to support the channel. So if you don't want to see ads on YouTube, please don't use an ad blocker. Please support the channels. But you can buy YouTube Premium, and when you watch with YouTube Premium this channel, it helps the channel. Let's begin. I have a special Judge Gildea for you. Take it away, Reporter Towel, Judge Gildea.
Commonwealth of Massachusetts, Plymouth, SS Superior Court. SIA number 26-00541. Jennifer McCabe and others. YS Karen Red and another. Memorandum of Decision and Order on defendants' motions to dismiss pursuant to Mass. R. Civ. P. 12. B. 6. In this action, plaintiffs Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins allege that defendants Karen Reed and Aidan Kearney conspired to defame them by falsely stating they were responsible for the death of Reed's boyfriend, John O'Keefe. The first, amended complaint, FAC, asserts claims against both defendants for defamation, intentional, and negligent infliction of emotional distress and civil conspiracy. The plaintiffs also assert separate claims against Red for aiding and abetting in Kearney's defamation and infliction of emotional distress, and against Kearney for violation of GL Chapter 93A. The defendants have each filed motions to dismiss under Massachusetts Rule of Civil Procedure 12b-6. For the following reasons, the defendants' motions are denied.
Two things. One, remember, Karen and Aidan did joint anti-SLAPP motions, to dismiss, which we already reviewed under 59H, 231-59H. Judge Gildea denied those. Both Karen and Aidan appealed them immediately. When I read the decision, I called they would appeal them. They appealed them. This is a separate ruling. Okay, so the anti-SLAPP and the 12b-6 motions to dismiss were in the same motions for Aidan and Karen, respectively. An anti-SLAPP motion to dismiss is, Your Honor, dismiss this because I was petitioning the government, and if you allow people to sue me, it would be a strategic lawsuit against public participation. So dismiss it. Judge denied that. 12b-6 is, Your Honor, in the context of the rules of civil procedure, under Twombly and Iqbal, this lawsuit filed by H.A.M fails to state a claim upon which relief can be granted. Under Twombly and Iqbal, that standard is the plausibility standard, which means there needs to be a plausible allegation of facts on the surface of the complaint. It needs to be a well-pleaded, plausible complaint. Judge Gildea is now analyzing these. We're moving away from anti-SLAPP law and into the realm of 12b-6. A 12b-6 is a pre-summary judgment, which is 56F, a pre-summary judgment, pre-discovery motion to dismiss. Everybody on the same page? T.A. Sarah is taking notes. This will be on your final. Let's begin.
Background. The FAC alleges the following facts relevant to the motions. On January 29th, 2022, in the middle of a snowstorm, Red struck O'Keefe with the back of her Lexus SUV while she was driving drunk, leaving him to die on the front lawn of 34 Fairview Road in Canton. Reed made incriminating statements to first responders on the scene. An investigation into O'Keefe's death resulted in Reed's arrest, indictment, and prosecution for Brian Albert, Colin Albert, and Brian Higgins. Aidan Kearney. Murder. Attorneys Alan Jackson and David Yannetti represented Red in connection with the prosecution. In January 2022, Kearney's occupation was that of an aspiring internet personality. His objective was to attract attention to himself, to build a brand and monetize his audience. To do so, he routinely engaged in provocation and courted controversy.
Okay, Aidan Kearney is the reason Monica Cater-Grant got charged. Aidan TurtleBoy Kearney is a journalist whose material is read by the federal government. What is this saying? Even in the light most favorable to the plaintiff, this is wrong.
H.A.M Reed was arrested and indicted on murder and related charges in June 2022. She was falsely blaming others for O'Keefe's death to escape responsibility. To facilitate the spread and publication of her lies, Reed found and enlisted Kearney. In April 2023, Reed began communicating with Kearney through an intermediary and her counsel to conceal her relationship and create plausible deniability of her role in Kearney's false claims. Kearney agreed to publicize and widely disseminate Reed's false claims about the plaintiffs to destroy their reputations so Red could evade responsibility for causing the death of O'Keefe. Kearney acted on behalf of Red in publishing defamatory statements about the plaintiffs to assist Reed in her trial by harassing the witnesses, harming their reputations, tainting the jury pool with false claims, and intimidating the plaintiffs to not testify or change their testimony. As part of the scheme, Reed included gratuitous material in her pleadings filed in court to launder information to Kearney. On April 12, 2023, Red filed a discovery motion to obtain Brian Albert's phone, in which she falsely stated that Brian and Colin Albert were responsible for O'Keefe's death, and McCabe was the mastermind who covered it up.
Just so everyone understands, what Judge Gildea is doing is ostensibly reading the H.A.M complaint in the light most favorable to the plaintiffs. Whether he's actually doing that is up for debate, but I want everyone to understand. What he's doing is making a recitation of the facts in the light most favorable to the plaintiff, as required under the 12b6 standard. Whether this is the light most favorable to them or not is up for you to determine.
Reed also attached several irrelevant and non-public documents to the filing, including an unredacted copy of a Canton police report that listed the plaintiffs' addresses, cell phone numbers, and social security numbers. In addition, Reed provided other selective and distorted information to Kearney that she purportedly obtained from federal law enforcement authorities that was not public. With the encouragement and direction from Red, Kearney published his first blog post about the matter on April 18, 2023. He shared his draft to Reed through the intermediary, and Red provided dozens of corrections, which he adopted. In part 1 of Kearney's Cantoner cover-up series, Kearney wrote that Brian and Colin Albert were more than capable of killing O'Keefe, and that McCabe was the quarterback of the cover-up. FAC at paragraph 33. On April 20th, 2023, Kearney met with Reed's counsel. 2 days later, at Red's direction, Kearney made additional false statements during his live show that Brian and Colin Albert killed O'Keefe. During that show, Kearney used the phone numbers Reed made public to call McCabe and Brian Albert. He left a voicemail on Brian Albert's phone asking, "Did you kill John O'Keefe, or was it your nephew Colin? And are you covering for him? How did your dog get downstairs and begin biting Mr. O'Keefe?" F.A.
Free Chloe! Free Chloe! Listen, ladies and gentlemen. Free Chloe! Free Chloe, she was a federal informant dog. Free Chloe! Free Chloe!
See at paragraph 37. Later in that show, Kearney displayed images of the Canton police report with the plaintiff's personal information. After that, the plaintiffs began experiencing disturbing levels of defamation, harassment, and abuse by members of Kearney's audience. Despite repeatedly deceiving the public about her coordination and relationship with Kearney before, during, and after her criminal trials, Reed and Kearney coordinated to defame the plaintiffs to subvert the Commonwealth's prosecution, attract an audience, and monetize that audience and their celebrity. Reed regularly funneled non-public material for Kearney to selectively publish to cast false suspicion on the plaintiffs. For instance, Red falsely told Kearney through the intermediary that Brian Albert, his wife, and Colin Albert's parents all testified before a grand jury that Colin Albert was at 34 Fairview Road on January 29, 2022, after O'Keefe arrived. No witness ever made such testimony. Eventually, Reed and Kearney sired it.
Excuse me? How does Judge know that? How did their counsel know that? They might know what they say they testified to, but how do they know? How does Judge know? what the federal grand jury... That's such an authoritative statement. Do you have the federal grand jury materials, Judge? Maybe you do. Are you telling me that... Is that what they're saying? And you're accepting as, like, favorable to them as an assertion of fact? Or Judge, are you saying that? I'm very confused.
Communicating directly utilizing Signal, an encrypted messaging system that avoids detection and aids deletion of communications. On May 3rd, 2023, Kearney met with Red and her...
Wait, I thought this is what Judge Gildea sounded like. Listen, I'm autistic, so, you know, I'm serious. I don't always hear tone. So I thought this, I have to, like, pick from voices when I made this. You know, I produced this, I made it. I had to generate the PDF. I made the text file. I made the voiceover. And I thought this is what Judge Gildea sounded like. Maybe I got it wrong. I'm sorry about that.
Attorneys to coordinate his publications with Reed's litigation and media strategy. That same day, Kearney posted a video stating that Brian and Colin Albert murdered O'Keefe and every other single person in that house who remains quiet to this day and participated in the lie. They're all guilty of murder as far as I'm concerned.
Well then, exasperated, shocked, and a little bit confused about, you know, what he's supposed to do in his life, voiceover man, you certainly have some strong opinions.
FAC at paragraph 54. Based on prior publications, his followers would have understood. This as including McCabe and Brian Higgins. On May 7th, 2023, Kearney acknowledged to the intermediary the incoherence of Reed's two narratives that O'Keefe was killed shortly after entering the house and that McCabe performed a Google search at 2:27 a.m., suggesting he was still alive, noting the Google search. Allegations made no sense if Reed's theory was that O'Keefe was already dead. Kearney called it a frame job and told Reed's intermediary, "I hope Reed realizes that the Googie search completely invalidates the defense, and it's starting to make me worry about what I've now tied myself to."
The Googie search. Jen McCabe did a Googie search. Wait a minute. Are you telling me that the reasons this motion to dismiss is going to get denied are Natalie the German, who was the most obvious operative in the history of operatives, and eventually we're going to find out also because of that turncoat documentary producer? Are you serious? And we think these people weren't operatives? I see what the real plan here was. Wait till you see parts of this ruling. It's almost like Natalie knew what she had to get Aidan to say at certain times. Like, I'm telling you, if we find out these people were paid operatives who inadvertently were running this stuff on a federal investigation and cooperating witnesses, oh, dude. Oh, my God. Like, I'm a Bill Cooper guy, right? And Bill Cooper hated Alex Jones. He thought he was a scam artist, all right? That was Bill Cooper's opinion. I don't like Alex Jones, okay? I think his dad works for the Defense Intelligence Complex at UT Austin, okay? I think he's a scam artist. I think he absolutely ran his mouth about those dead children, and it was disgusting, okay? And he deserved everything that happened to him. And I'll tell you right now, he deserved probably more consequences for what he did to those families. That was disgusting. All right? That was deserving, in my opinion, of this kind of operation. Because what Alex Jones did was disgusting. Abhorrent, gratuitous, predatory, vulture-like. And he deserved everything that happened to him. He's a monster. Sorry, that's how I feel. How dare you do that to those kids? That was disgusting. And thus, if these lawyers did that to him, no one's going to have a problem with it. This is not that case. I get now what was attempted. This is not that case. He is not that guy. Aidan is not Alex Jones. Aidan kayfabes so that he can do investigative journalism. Alex Jones is a crazy man. Well, in my opinion. And I think a jury might have defaulted. Alex Jones would say absurd things. Even back during Y2K. You ever listen to his Y2K broadcast? Bill Cooper ripped them apart. Alright? For good reason. You want to run that kind of up on Alex Jones? I don't care. I don't care. Do it. He was a dangerous man. Whoever convinced this group, and I'm not sure who was witting and who was unwitting, that Aidan Kearney was Alex Jones, they got sold a bill of goods, in my opinion. They're just not the same person. No matter how much you want to dye your hair blonde and follow an anorexic standard of beauty, to quote my favorite lyricist, you will never be them. And I just don't understand. Oh, God bless you to Moon Eternal. If your name is Phoebe Dinros, or Ree, oh, that's so wonderful, Ree, you got a gift membership, or Lindsay LaFair, or Wednesday 21, or Callie Tinfoil Hat Thinker, ironic, feel free to enjoy your new towel emojis. You can just click the emoji button in the chat. I made them all myself. I'm not embarrassed. I'm a good artist. I realized I was blushing a little bit because I made all this art. So we have penguins. Chat Mom Lynn loves penguins. We have goats. We have sheep. We have Towel Chat Mom's bunny. Towel Chat Mom Bunny's dog, Kofi. We have David Yannetti as a custom emoji. I made him a tribute. He's the man on the mountain. We have Chloe the dog in a wake. And then we have all sorts of towel-based emojis. We have the Stay Puft Marshmallow Man, because Alan Jackson referenced the Stay Puft Marshmallow Man during trial. And I was like, Al, if you're going to reference the Stay Puft Marshmallow Man, I got to make an emoji out of it. You know what I'm saying? Oh, Peep, the channel mascot, he is also an emoji. Oh, April says, thank you for your awesome work. Take it easy on yourself. God bless you all. I'm an okay artist. I'm more of a towel weatherman. I'm not actually a weatherman. I'm a court document analyzer. I'm not a lawyer, though, but I did go to law school. All right, let's continue. But the point is, this is outrageous. Just outrageous. I can see exactly what happened here, and it's going to get worse. You're going to see the most damning, quote, evidence against Karen and Aidan came from Natalie and that documentary producer. That's why they lost this part of the motion.
FAC at
And
par.
it's not even damning, like, evidence. It's almost like they got baited into saying things to these informants, and then they said them, and it's very sparse stuff. Like, very de minimis stuff. I mean, Karen like said some stuff to the documentary producer that was almost like the only thing that allowed this lawsuit to survive a motion to dismiss, at least the part about Karen's direct statements, not the accessory part. It's like they were baiting them. Like, Natalie wanted Aidan to say, like, hey, that seems incongruous to Karen's theory, and you're going to find out there's case law that aligns with a lot of this stuff, which really has me on edge.
55.
Because Natalie the German does not know about the civil standard for what you need to meet a claim of bad faith or like acting with actual malice. Okay, she doesn't know there's some random case that says if you question the integrity of your source's theory, then that's enough to get you over. If you get sued, that's enough to sustain the lawsuit in the face of a motion to dismiss. Natalie the German does not know that. Natalie the German does PR. You know who would know that? A civil lawyer. April says you are the best. God bless you, April. You're so kind. All right, Judge Gildea, take it away. It's not actually Judge Gildea. This is just what I thought he sounded like.
To conduct any diligent inquiry. Abandoned. Journalistic standards disregarded the obvious flaws and inconsistencies in Reed's theories. And continued to act at Reed's direction in disseminating those allegations to the public. On July 22nd, 2023, Kearney conducted a rolling rally where nearly 50 cars drove in. Tandem through the streets of Canton to express support of Red. The rally stopped at Bryan, Albert's, and McCabe's homes where Kearney shouted into a bullhorn that they were covering up a murder. In addition to using Kearney to seed public discourse, Red, through her counsel, hired a private investigator, Sarah Ness, who has previously worked with Jackson to discredit victims of Harvey Weinstein crimes. On September 17th, 2023, at the direction of Reed and
Typo! Typo alert, ladies and gentlemen. We have a typo alert. That's it. Throw the whole thing out. That's it. Typo alert. First of all, that's a ridiculous sentence. Second of all, Harvey Weinstein's with a possessive. Typo alert. Throw it out. Throw the whole... That's it. Throw the whole thing out. That's it. A moment. You can't make a... listen. I know judges will be like, it happens, but my standard is if a judge makes a typo, then by rule the whole thing gets thrown out. Typo! Typo! I object. Your Honor, I object. I appeal. There was a typo. Sir, that is... Mr. Ellis, that is not grounds for appeals. Yes, it is! No, it's not, Mr. Ellis. You can't just say it is. Yes, I can, Judge. Damn it. Mr. Ellis, are you going to go write a law saying that if a judge makes a typo, the entire decision is invalid? Yes! You damn right I am!
Jackson Ness visited the home of Higgins to question him while Reed and her counsel watched from an SUV. Higgins refused to speak with Ness. Following that interaction, Reed and Kearney directed additional defamatory statements at Higgins. Ace, a law enforcement special agent with cover responsibilities. Higgins suffered profound damage to his career because of the defendant's false and widely publicized statements that he was involved in O'Keefe's murder. Kearney has personally harassed Higgins at his residence multiple times for the purpose of confronting him and generating content to be published on Kearney's platforms.
Excuse me? Wait a minute. Wait a minute. Are we starting to see a potential civil witness list develop for the H.A.M plaintiffs? Who am I thinking? Let's see. Natalie the German. Who else? Meredith. Meredith was with Aidan when he went to Higgins down the Cape. Weren't they? I wonder why they went by Higgins' house down the Cape. I wonder how Higgins knew they were coming. Interesting. Anyway, so and then who else? Oh, the Terry Maurer, the documentary producer who was so friendly to Karen at first and then flipped on her. Wow. Very interesting. You know, what about... I have a lot of questions. Let's keep listening. I think I'm starting to see the H.A.M plaintiff civil witness list.
Kearney's popularity has increased significantly because of his working with Reed. In his internet-based shows, Kearney hawks merchandise related to his Canton Cover-Up series. He also asks his followers to donate directly.
Judge, he hawks? He hawks? What do you think, he's selling effing peanuts and sausages and programs outside of Fenway? Programs! Get your programs here, $2, $2.50. They up the price. Programs! He's hawking? He's hawking, is he? He's hawking! April, God bless you. April's going to single-handedly drive us to a dance party. Listen to me. Hawking? Hawking is where you sell programs outside the Red Sox game. TurtleBoy does a lot of things. He doesn't hawk anything. You've reduced your judge. You've reduced him to a peanut seller outside the Red Sox game. I mean, come on now. Could you show... I mean, Judge, you can pick lots of words there. It is not 1930. He's not selling straw hats on the side of the road. This is ridiculous. Could you drip with any more disdain for him? Hawking? All right. Ladies and gentlemen, I would like to hawk to you. Let's see. I would like to hawk to you. I don't even know how to hawk. I don't have anything to hawk. This is absurd. What can I hawk to them? Like a program? I need like a program to a baseball game. I need some peanuts. I need a hot dog. Like, what are we? What is going on here, hawking?
Directly to him on his homepage and in his posts, personally. Recognizing audience members who send him money.
Oh my goodness. He recognizes the people who donate to him. Ladies and gentlemen, he doesn't just hawk peanuts. He says thank you to the people who support him. This is a travesty. It's a sham. It's a mockery of justice. Your Honor, he was hawking the program, and at the same time, when people would buy the program, he would say thank you. This man is a monster.
Kearney's followers buy subscriptions, donate to him, purchase his merchandise, and visit his platforms, which boosts his attractiveness. To advertisers. During Reed's first trial, she had a documentary filmmaker.
So basically, he's the opposite of Kate Peter. Okay, I got it. Judge, I got it. He's both a peanut seller who hawks, programs outside of the game and is an aspiring internet personality. And at the same time, this is all true at the same time. He has a large following who donate to him, buy his hawked game programs for the Red Sox, obviously, down at, on Yawkey Way. Call it whatever the hell you want, bro. It's Yawkey Way. Take it from my, cold, dead hands. All right? And then he has a large following of people who buy subscriptions, donate to him, purchase his merchandise, and visit his platforms, which all have boosted his attractiveness to advertisers. So which is it? Is he some irrelevant Kate Peter-like, internet troll? Or is he like a highly effective journalist with a massive amount of supporters? How can both of these things be true at the same time? Even if they're well pled and read in the light most favorable to the plaintiff, they can't both be true at the same time.
Terry Muir recorded the trial. Preparation which included conducting recorded interviews with Red over the course of the trial. During an April 30th, 2024 interview, Reed stated that Jen McCabe is a first degree murderer, and she knows it, that the plaintiffs know they killed John, and that plaintiffs are murderers, and they know it.
All right, Judge Gildea Towel, I realize you feel strongly about this, okay? Towel News reports what the court document says, all right? Judge Gildea wrote this. He quoted it, all right? Judge Gildea Reporter Towel is saying it, okay? But you know what? This is getting dangerously close to our rule on personalities here, Judge Gildea Reporter Towel. Now, I had a stern conversation with Reporter Towel the other day about certain words in court documents and violating the standing rules of the Towel House. He asserted his editorial independence and told me I could go F myself. So, I don't know what you want me to do.
FAC at paragraphs 93, 95. On June 15th, 2024, Reed told Muir and her team that Brian Higgins, Brian Albert, and Colin Albert had a motive to kill O'Keefe. And during another interview on June 22nd, 2024, Reed told the filmmakers that she knew Brian Higgins had a role in helping kill O'Keefe and helping frame me, I think. Brian Albert and Colin Albert would have enjoyed roughing John up. FAC at paragraphs 96 to 97. Reed made these statements knowing the plaintiffs had nothing to do with O'Keefe's death. Reed's first trial ended in a mistrial. Thereafter, Reed and Kearney continued to publish statements that the plaintiffs were responsible for O'Keefe's death and cover-up. Red's second trial ended in an acquittal of the murder charge on June 18th, 2025. Immediately following the conclusion of the second trial, Kearney stated to NBC 10 Boston that Brian Albert and Higgins were there when O'Keefe died, though he did not know who delivered the fatal blow.
I swear to God, if Sue O'Connell or NBC 10 turns up as a H.A.M plaintiff witness, I'm declaring a formal writ of shenanigans, and I'm annexing the north of France, and I'm sending Boozy Beauty to run it as the governess, or the queen, whatever she wants to style herself. That's it! I swear to God. I knew it. I knew Sue O'Connell was a rat. That's my, not a rat to anyone in particular. Just, she had the vibe of someone who would sell you, just in my opinion, she gave off the vibe of someone who would just, screw you in a second. So, I'm telling you. Bro, and she also talks to my mom. Remember when she told me, when I was standing next to Gretchen Voss in line, that she was going to call my mom because I kept running my mouth about Sue being friendly with Karen's parents. And Sue was like, I'm going to call your mom. And I was like, Gretchen, look at this conversation, like it was in 2024. Look at the last conversation I had with my mom. It was me yelling at her about the Birchmore cover-up because she was yelling at me about talking about the Birchmore cover-up. And I was like, and then I showed Sue O'Connell my tattoo. This one. Where is it? And I was like, Sue O'Connell, you call my mom, okay? You call my mom. Please do, Sue O'Connell. Okay, I got that the day I turned 18, Sue O'Connell. And I was like, wait a minute, she talks to my mom. My mom hates Karen and Aidan. I should have known. Owl, even if we get a little buffer. My point is, look at all these statements that are forming the basis for why this motion is going to be dismissed, and actions. Every one of them involves either Natalie the German, Meredith, Sue O'Connell, the Turncoat documentary producer. Seriously. Everybody was working everybody.
FAC at paragraph 126. On November 2nd, 2025, on his live show, Kearney admitted that he had lied to Boston Magazine about his relationship with Red. He stated that the Reed team did not want to be publicly associated with him. They wanted him to do the work of getting the story out there about what the McAlberts have done. FAC at paragraph 129. Kearney has continued to accuse these plaintiffs of being responsible for O'Keefe's death since the conclusion of the second trial.
I mean, Judge, shouldn't you also say where Reed was acquitted for O'Keefe's murder? Now, that's the end of what's called the facts section. That's where the judge is reading the facts in the light most favorable to the plaintiffs. He's cherry picking from the complaint, but that's the standard. Now we're shifting into judge's actual ruling. Oh, it gets worse. Listen, if you are mad, it's about to get worse. This is Chat Mom Lynn. Hello, how you doing? This is Judge Gildea's ruling that just came down an hour ago, denying Karen and Aidan's motion to dismiss under 12b-6 the H.A.M civil lawsuit in Plymouth. This next part is where Judge is actually going to stop talking, and it does not get any better. It gets worse.
Discussion. To survive a motion to dismiss for failure to state a claim pursuant to Massachusetts Rule Civil Procedure 12b-6, a complaint must contain factual allegations plausibly suggesting, not merely consistent with, an entitlement to relief.
Pause, ladies and gentlemen. I have wonderful news. Tiffany Bob's towel hoodie has arrived. So with Chat Mom Lynn and Tiffany Bob, our first two. Now listen, I now understand what hawking is. All right, Judge, this would be hawking, which Aidan does not do. Ladies and gentlemen, the greatest clothing items, in my opinion, of all time have arrived at the doorsteps of the two most honorable women in the United States of America. The people who have single-handedly uplifted the spirit of our country, overthrown the damn commies, and supplanted the anti-Western world with American greatness. Tiffany Bob and Chat Mom Lynn. Their towel sweatshirts have arrived. Now, this is a glorious and momentous day for towels worldwide. Yes, it will go down in the annals of towel history. You will remember where you were when this moment went down. God bless these United States of America. Yes, I'm telling you, the history books 500 years from now will tell the story of this moment, and you were here for it. Now that's hawking. All right? I just want to get everyone on the same page. That is hawking.
Giannichino.
Actually, you know what? For demonstrative purposes, say you were thinking to yourself, wait a minute, Towel has merch. Not only is he making a metaphysical commentary on Judge Gildea, But there's a towel store? Oh, you damn right there's a towel store. And ladies and gentlemen, let me just tell you that I don't think that there could ever be a more perfect moment to tell you about bonfire.com/store/towel-shop, the link that you can click in the chat, which would allow you to get all of these wonderful towel-based items. Yes, there's an apron with the Towel Channel mascot, Peep, that says, "That's it, I'm mad." There's a towel, it's a golf towel. There's a towel tea towel, hashtag I'm Towel Vanna White. This is great. And there's a towel news blanket, it's a full bed blanket. And then there's the item that I think everybody loves, which is various t-shirts and whatnot with the towel news bunny that says, "That's it, I'm mad." I think that's what Tiffany Bob got today. Now listen, ladies and gentlemen, you can obtain these items from the link in the description, or since I'm teaching you about what the word hawking means, you can click the link in the chat. Okay, you're buying them from Bonfire. Buyer beware. Look at the terms. Pick your colors carefully. Did you know that this V1 print? Oh yes, there is a pink version. And when you select the pink version, the bunny's eyes and teeth turn pink. You don't understand? It's the greatest thing you've ever seen, ladies and gentlemen. Yes, I am hawking. You know what? Judge wants to talk about hawking. I'm going to pull a Melanie Little. I got the Melanie Little head on. I'm going to do it. I did it. Look how great that was. Hashtag support towel. Anyway, God bless you. There's other ways to support. I'll throw the links in the chat. Feel free to support Towel News. There's a Cash App, there's Venmo, there's a PayPal. I did have to pay to generate this voice, but it doesn't, we do what we can. So if you want to spread it out, there's links on the screen, those little QR codes. The Cash App's # Grant Smith Ellis, the Venmo's at Grant E1, the PayPal's paypal.me/Grant Ellis. God bless you all. Thank you for your support of Towel News, where I strive to educate, inform, and entertain you, such as to engender, cogent public discourse, and ward off the usurpation of our forms of government worldwide.
Versus Ford Motor Company, 451 Massachusetts, 623, 636, 2008, quoting Beale Ale Corporation versus Twombly, 550 U.S., 544, 557, 2007. The factual allegations must be more than labels and conclusions and raise a right to relief above the speculative level. Vanakino, 451 Massachusetts, at 636, quoting Twombly, 550 U.S. at 555. In assessing a complaint under Rule 12, B, 6, the court accepts as true the well-pleaded factual allegations in the complaint and draws all reasonable inferences in the claimant's favor. C. Fairhaven House, Auth. V. Commonwealth, 493 Mass, 27/30/2023. In addition to the factual allegations within the complaint and any attached exhibits, the court may consider matters of public record, items in the record of the case, and documents relied upon in framing the complaint. See Merrim versus Cobrick Offshore Fund, Limited, 442 Massachusetts, 43/45, Note 4, 2004. Shayer versus Brandeis University, 432 Massachusetts, 477, 2000. 1. Kearney's partial motion to dismiss. The plaintiffs assert claims against Kearney for defamation, intentional and negligent, infliction of emotional distress, civil conspiracy, and violation of GLC 93A. Kearney's motion makes two arguments for the partial dismissal of these claims. First, he contends that as to Brian Albert and Higgins, who are both public officials, the defamation claim fails because the facts in the FAC do not plausibly allege that Kearney published statements about them with actual malice. Second, he contends the claim for violation of GL Section 93A should be dismissed because there are no allegations that any of the plaintiffs had a commercial relationship with Kearney. The court is not persuaded by either argument. A. Defamation of Brian.
We had a question of what my tattoo was. It is a tattoo of a sun with mom above it and then a knife going through the sun. Got it on the day I turned 18 at Redemption on Mass Ave.
Albert and Higgins. To state a claim for defamation, a plaintiff must allege: first, the defendant made a statement of and concerning the plaintiff to a third party. Second, the statement could damage the plaintiff's reputation in the community. Third, the defendant was at fault for making the statement. And fourth, the statement caused economic loss, or in 4 specific circumstances is actionable without economic loss. Schultz versus Dipe, 473 Massachusetts, 242, 249, 2015. Quoting, Ravnikar versus Bogojavlensky, 438 Massachusetts, 627, 629 to 630, 2003. If the plaintiff is a public official or public figure, the plaintiff must also establish that the defendant made or published the defamatory statement with actual malice. LeChance versus Boston Herald, 78 Massachusetts Appeals Court, 910, 911, 2011. The actual malice standard requires the public figure to prove that the statement was made either with knowledge that it was false or with reckless disregard as to whether it was false. Edwards versus Commonwealth, 477 Massachusetts, 254, 263, 2017. Reckless disregard requires more than negligence. A plaintiff must prove that the individual making the alleged defamatory statement entertained serious doubts as to the truth of the statement. Judy, quoting Saint-Amand versus Thompson, 390. U.S. 727, 731, 1968. See Garrison versus Louisiana, 379, U.S. 64, 74, 1964. Defining reckless disregard as high degree of awareness of Massachusetts, 517, 530, 2013. Quoting Rotkiewicz versus Sadowski, 431, Massachusetts, 748, 755, 2000. Because direct evidence of subjective belief rarely exists, a court will typically infer actual malice from objective facts, internal quotation and citation omitted. Lemelson versus Bloomberg LP, 903 F. 3rd, 1924, First Circuit, 2018. C. Edwards, 477 Massachusetts, at 264. Plaintiff may rely on circumstantial evidence to prove that a defendant had actual knowledge that the statements were false or had serious doubts about their accuracy. Assuming without deciding that Brian Albert and Higgins are public officials, and therefore must demonstrate Kearney published his statements about them with actual malice, the FAC contains sufficient allegations to maintain the claim. In particular,
Hold on. This is huge. Do you understand what it means to survive a motion to dismiss when the court's presuming they're public figures on a defamation claim? I mean, listen. Public figures, it's a very, very, very intense standard for the plaintiff on purpose. Every part of it. And judge is like, well, they're public figures, so you need actual malice. Do you know what actual malice means? He just defined it, judge. I mean, it's like basically judge saying that he thinks that everything that Aidan and Karen that he's going to quote here is alleging is false. And not just false, everything that Aidan said, judge is basically saying, I think this was made with reckless disregard from the truth. Oh, ladies and gentlemen, I have a big announcement. Towel Mom Bunny got her sweatshirt. It's gray. I bet Kofi's having a day. Bo's probably having a day. Been praying for Bo's mom. Hope she's okay in recovery from her treatment, surgery. But Towel Mom Bunny has brought joy to Kofi and to the dogs worldwide. Maybe not the horses. She has her shirt. They are all arriving. If you got your orders in on whatever the first day was that I put this up, like 5 days ago, I think about then, you got them. So the arrival time, based on what I'm seeing, is about 5 days. That's great if you're in America. So, Towel Mom Bunny, I love you dearly. Hi, Kofi. How you doing? Kofi's a dog. Bunny is having a day right now. She got her towel sweatshirt. She has Peep on her right now. She's probably going to be able to wear it. It's a sweatshirt. It's all comfy. I can't wait to find out. I can't wait to see pictures. All right. We'll give people a day or two. I absolutely would love to see some pictures. We'll put them in. It'll be great. I'm all excited. I'll get the. Now, if you want me to show the picture on the stream, remember there's a lot of countries that watch all that good stuff. So, maybe you want to like only show the sweatshirt, whatever you want to do. Think about it. I'd love to see them. God bless you all. What a special day for Bunny, Towel Mom, and Chat Mom Lynn, and Tiffany Bob. I forgot about Tiffany Bob. How could I forget about Tiffany Bob? It's a glorious day to be a towel.
The FAC alleges that on May 7th, 2023,
we are very close to a dance party, ladies and gentlemen. I will break in to do a dance party, I promise. We're very close, but we're going to get through this document.
Weeks after Kearney published his first blog in the Canton cover-up series, he acknowledged to the intermediary a contradiction in the narrative Red provided him regarding O'Keefe's death. Kearney noted that if O'Keefe was killed shortly after entering 34 Fairview, as Reed had told him then, the allegation that McCabe performed a Google search at 2:27 a.m., suggesting he was still alive, made no sense if Red's theory was that O'Keefe was already dead. See FAC at paragraph 55. Kearney told Reed's intermediary, "I hope Reed realizes that the Google search completely invalidates the defense, and it's starting to make me worry about what I've now tied myself to." The FAC alleges that Kearney disregarded the obvious flaws and inconsistencies in Reed's theories and continued publishing false statements at Reed's direction, where Kearney deliberately ignored evidence that called into question his published statements. Such allegations plausibly suggest recklessness amounting to actual malice.
Oh my word, you understand that? Can you believe this? Now let's listen to Judge's explanation for why Aidan's retort to that was rejected. Judge is saying that because Aidan said one sentence to Natalie in a conversation about the Google search, and who knows if Natalie was confusing him, trying to sandbag Karen or what. Because Aidan said that, Judge is inferring for everything about Higgins and Brian Albert that there was actual malice because of that one thing, which was very early in Aidan's role in the case. And I bet he probably you're not even like thinking about, well, what could that actually mean? He's just thinking through the standard to Natalie, and oh, damn it, Natalie was a third party. So they were getting Aidan to publish defamatory statements to Natalie, even though they're not really defamatory, they're just being used against him. He was thinking out loud to Natalie, to Karen. Oh, using Natalie was such a bad idea. Because that was not his final position. Oh, this is absurd. Welcome, Cult Jam. We're glad to have you. Oh, I told you were going to be made. I tried to tell you. Now listen. We're going to listen to what Judge says about why Aidan's response to that was rejected. Then we're going to read the Levesque versus Ducey case, and I'm going to find out if Aidan's statements deliberately ignored evidence that called into question his published statements, okay, based on what Judge cited to, the Levesque versus Ducey case. Then I'm going to compare and contrast, all right? That's what we're going to do. But first we're going to finish the paragraph about why Aidan's response was rejected.
Levesque versus Ducey, 560F, 3rd 82, 90, First Circuit 2009. Kearney disputes that the allegations in paragraph 55 of the FAC are adequate to plausibly suggest knowledge or recklessness of falsity. He argues that the allegations express only doubt as to the Google search conducted by McCabe and that 2 articles he published days after May 7th, 2023, demonstrate he conducted further investigation to remove his doubt. However, Kearney's argument fails for 2 reasons. First, the articles cited were not relied upon in the framing of the FAC, and therefore are beyond the scope of what this court can consider on a motion to dismiss. C. Hladek versus LPL, Financial LLC, 106. Massachusetts Appeals Court 592.
Oh my word, the judge's logic is that even though the First Amendment complaint says that Kearney published 445 parts of the series, and even though judge is going to go on to say that the conspiracy of it all was implied through the entire framing of the narrative, judge is like, yeah, Aidan's not allowed to talk about the parts of his articles where he clarified his statements to Natalie about the Google search, because those weren't referenced in the First Amendment complaint. And even though all 545 articles were mentioned, that doesn't really count, because the articles Aidan wrote about clarifying that statement he made to Natalie, that wasn't really part of the framing of the complaint, so I'm going to ignore those. Oh God.
599 to 600, 2026. Second, Kearney's argument depends on the court accepting A.'s interpretation of his statements. In paragraph 55, and in his subsequent articles, and drawing all inferences in his favor. However, that is not the correct analysis on a Rule 12, B, 6 motion, construing all reasonable inferences in the plaintiff's favor, as the court must on this motion, see Fairhaven House. Auth. 493 Massachusetts at 30, paragraph 55, plausibly suggests that Kearney entertained serious doubts as to the truth of his statements about the circumstances of O'Keefe's death, and therefore acted in reckless disregard for the truth. See Edwards, 477 Massachusetts at 263. The allegations are therefore sufficient for actual malice at this stage.
Oh my goodness. Do you understand what he just said? Because, first of all, what do Brian Higgins and Brian Albert have to do with Jen McCabe's Google search? This is absurd. I was mad at first. I might have been getting my chicken during this part when I first listened to this. Oh my. Do you understand what Judge just said? Because Aidan expressed an initial scintilla of doubt about what was going on with Jen McCabe's Google search, which, by the way, isn't even the biggest bombshell there. It's that the WallDB file wasn't included in the initial extraction given to Karen's team in 2022 by Tully, who's Jen McCabe's friend, given to Karen's team via Tully through Adam Lally. What's more outrageous here is that Judge is saying, listen, everything that Aidan said about Brian Higgins and Brian Albert was completely reckless and based in actual malice, because Aidan expressed one time, that's all Judge relies on, to Natalie, that he had questions about the Google search. Jen McCabe's Google search, which has nothing to do with Brian Higgins and Brian Albert. Although the butt dials from Brian Albert to Brian Higgins were right around then. It was like 2:22 a.m., which is a little weird. But my point is, do you see what I'm saying? Judge is like, well, for Brian Albert and Brian Higgins, I'm just going to assume they're public figures, public officials. They were cops. And, even if they are, one time Mr. Kearney expressed to Natalie, the German, while he was using Natalie as an intermediary to talk to Karen, just one time, Aidan said he had questions about what the 227 search meant. Now, I realize Mr. Kearney says he immediately corrected that and explained those doubts, but I'm not going to focus on that, because even though the rule is that if it's mentioned in the First Amendment complaint by the plaintiffs, and even though all 545 articles were mentioned, I am saying that that follow-up article by Kearney wasn't used in the framing of the First Amendment complaint, so I'm going to ignore it. I'm just going to completely ignore that Mr. Kearney made reasonable due diligence and undertook efforts to understand the Google search more and express a conclusion that was in line with what he originally felt about the case, even after researching it more. I'm going to ignore all that. Even though I should technically consider it, I'm going to find a loophole and just not even acknowledge that. And then I'm going to rule that because those statements to Natalie, the German, in isolation, are an example of Aidan questioning the validity of Karen's theory, that is enough for a reasonable person to infer actual malice against Higgins and Albert. Excuse me? Talk about stretched thin. I've never seen anything stretched so thin. Not to mention, and this does get worse, not to mention, if we look at this case, Levesque versus Ducey, which I do have here, okay? And I want to make sure this is the correct site. It's F60 F3D First Circuit 2009. Okay? Yes. Okay? Wait till you hear. Oh, this gets ridiculous. Now I'm going to have British Reporter Towel do this one. I know some of you have missed your dear British Reporter Towel. Some love him, some hate him. We're going to have him do this one. We're going to do it quickly. Okay? And we're going to find out whether Judge is right that this case stands for the proposition that Aidan deliberately ignored evidence that called into question his published statements. Okay? We're going to see if it stands for that proposition. All right? So let me have old school British Reporter Tell do this for you. I know a lot of you have missed him dearly. He has missed you as well. All right? And we're going to start with, we're going to go to this case. And I'm telling you, you can't just take these judges at their word when reading an opinion. You got to really analyze it.
United States Court of Appeals. For the First Circuit. No 08-1814.
All right, let's get into it.
Stahl, Circuit Judge. Rare is there an opportunity to interrupt today's 24-hour news cycle, fueled by cable television's incessant need for content and the explosion of internet websites that publicly apprise us of events across the world. This appeal offers such a moment as we pause to review plaintiff appellant Leon Levesque's claim that defendants appellees Fox News Network, LLC, Fox, Steve Doocy, and Brian Kilmeade defamed him during a show on the Fox News Channel, FNC. The District Court, after considering Levesque's claims, granted the defendant's motion for summary judgment, and upon careful review, we affirm because his action is an appeal from a grant of summary judgment. We recite the facts in the light most favorable to Levesque.
Wait a minute. This guy sued for defamation and lost? And that's the case Judge is citing to?
Favorable.
Lost on summary judgment before trial.
Favorable to Levesque as non-movent. Epsilon. Fraternity. 528. F.3d. 94. 97. Fiaco vs. Sigma Alpha. 1 Street. CIR. 2008. The parties' dispute arises from a FNC morning coverage of an incident in Lewiston, Maine, where Levesque is the superintendent of the Lewiston Public Schools. On April 11, 2007, a student at Lewiston Middle School placed a bag containing leftover ham on the cafeteria table where Somali Muslim students were sitting for lunch. The Somali students reported the incident to Bill Broku, a Lewiston officer, -2, stationed at the school. After an investigation of the incident, the middle school's assistant principal suspended the offending student for 10 school days, a decision in which the principal concurred. The assistant principal classified the incident as hate crime, bias, in the school's computer system, and Broku filed a police report under the direction of his superior officer, characterizing the incident as crime, harassment, hate, bias. Levesque was informed of the suspension and endorsed the decision. The following week, while the Lewiston schools were closed for April vacation, Bonnie Washak, a reporter for the Lewiston Sun Journal, contacted Superintendent Levesque to discuss an article she intended to write about the incident. Published on April 19, 2007, the Washak article included quotations from both Levesque and Stephen Wessler, the executive director of the Center for the Prevention of Hate Violence, the center, which was working with the Lewiston Middle School to develop an appropriate response to the incident. Washak quoted Levesque as describing the offending student's conduct as a hate incident and acknowledging, "We've got some work to do to turn this around and bring the school community back together. Dot. Dot. All our students should feel welcome and safe in our schools." Wessler described the incident as extraordinarily hurtful and degrading, and warned that without a response, more degrading acts will follow, until at some point we'll end up having violence. Somali students reflected that the -3 event reminded them of an incident earlier that year when the head of a pig was rolled into a Lewiston mosque during a prayer session that many Somalis attended. On April 23, 4 days after the Sun Journal ran Washuk's article, Nicholas Plagman uploaded a piece he had written about the April 11th incident to Associated Content, a website platform that permits registered users to publish content on topics of their choosing. While the Plagman article purported to describe the incident as a news story, it mischaracterized some facts, such as reporting that the students left a ham sandwich, rather than ham steak, on the cafeteria table. Similarly, where Washak reported that the center was working with the school to create a response plan, Plagman described it as an anti-ham response plan. Plagman also included fictitious quotations which generally built upon those accurately used in Washuk's article. For example, according to Plagman, Levesque stated, "We've got work to do to turn this around and bring the school community back together. Again, these children have got to learn that ham is not a toy." Plagman also quoted Wessler as stating, "It's extraordinarily hurtful and degrading. They probably felt like they were back in Mogadishu starving and being shot at." Finally, Plagman falsely listed the Associated Press, AP, as a source, indicated that his contents, humor, story, and should news -4 be housed categories because Plagman under the Associated article was retrievable through Google News, a computer-generated website that aggregates headlines from news sources worldwide. Around 3:30 a.m. on April 24, a line producer for FNC's morning news talk show, Fox and Friends, discovered the Plagman article. Fox and Friends runs each weekday from 6 a.m. until 9 a.m. Its hosts discussing current events, interviewing guests, and reporting the weather. Producers 4. The compelling stories for the hosts to discuss. Show. Search. 4. The line producer sent the Plagman article to the Fox News Research Department for additional research. An information specialist was able to confirm some of the facts presented in the article, including the identities and professional positions of Levesque and Wessler, and the existence of the center, Lewiston Middle School, and the Lewiston Police Department. He also discovered the Washak article, confirmed that the Lewiston Sun Journal was a legitimate newspaper, and found 2 articles related to the incident at the Lewiston Mosque.
Excuse me, are you telling me that this judge, the case that this judge found, and is citing to support the proposition that Aidan deliberately ignored evidence that called into question his published statements, is one, a case that was dismissed on summary judgment, a defamation case, and 2, a case that involves some dude writing an obviously fake article that Fox News picked up and didn't really check the quotes and determined that this superintendent had said things he didn't say. Every single time. Now, LS, that's an interesting theory, but every single time you look into what judge cites a case for, it just becomes this farce, and that's why you got to do it. It seems monotonous, but you can't just take his word that that's what this case stands for, because it doesn't.
By 4:15 a.m., the Plagman article and research materials were delivered to 3 of the show's 4 co-hosts, including Ducey and Kilmeade. Ducey used Google News to conduct additional research and also found the Plagman article, the Washuk article, and a brief article on the Boston Globe's website which both corroborated the general story of the incident and confirmed that -5. The center was working with the school on a response plan. The defendants agreed to include the story in that morning's show. During the 3-hour cablecast, the defendants repeatedly raised and discussed the April 11th incident, frequently ridiculing Levesque, ascribing the handling of the incident largely to him. They reported as true several of the fabricated quotations that Plagman attributed to Levesque, including the H.A.M is not a toy statement, and also cited Levesque for the phony statement comparing the incident to Mogadishu, comment that had been falsely attributed to Wessler in the Plagman article. Throughout the cablecast, the hosts repeated these two falsified quotations and used the incident as the basis for the question of the day, inviting viewers to call or email the show to share their thoughts. Ducey and Kilmeade at times made statements that arguably called into question the veracity of the story. For example, Ducey on a number of occasions stated, "I am not making this up," once asserting that, "I've looked it up on a couple of different websites up there from local papers," and at various times, Kilmeade stated, "I hope we're not being duped, I thought this was a joke, and I thought this was almost from the Onion. .1. I didn't think that was actually true." The show's
Wait a minute. Wait a minute. Judge is comparing Kilmeade saying that to Aidan saying to Natalie the 223.7 search, mind you, only at first, calls into question Karen's version of the narrative. Are you kidding me? Are you kidding me? Another appeal incoming. Oh my goodness. There better be something else here, because that is not the same. The dude literally was like, I researched this, but, I kind of thought it was like the Onion. Should I maybe have checked these quotes?
One.
And Fox still won.
The Onion is a satirical newspaper that publishes parodies of real news stories. It publishes a print version and has an website.
That's true.
-6. For comment, leaving a message at his office around 8 a.m. 2
It's called
hours into the
Ann.
cablecast.
It's called an website, not a website? Okay.
Hours into the cablecast, Levesque did not return the calls. Sometime after the cablecast, Levesque contacted FNC to complain about the show's inaccuracies. Point 2. On May 16, 2007, Fox and Friends issued a retraction and apology, agreeing that various statements attributed to Levesque were fictitious and noting that, had the show realized the Plagman article was not legitimate, it would not have repeated the fabricated statements. The following month, Levesque filed a complaint asserting libel per se, false light invasion of privacy, and punitive damages, claiming that 5 statements made by the defendants during the cablecast were defamatory. Point 3. First, he took issue with the defendant's claim that he classified the incident as a hate crime. He next objected to the defendant's references to an H.A.M response plan. Third, Levesque asserted that the repeated mentions sandwich of H.A.M were defamatory. Fourth, he challenged the statement, Leon Levesque, he says, these children. 2. After the April 11th incident, Levesque began receiving
Yes,
derogatory and threatening emails and phone calls from persons who
I didn't even notice that.
United States Court of Appeal.
Oh, come on. What are you doing?
United States.
What? I didn't want you to start over. Now I gotta go all the way back to right before page 7. Alright, hold on one second. Alright, hold on. Where is it? Where is it? Right before page 7. Alright. This, now you see what a ruling actually is, though. You have to look at what, not just what judge is saying, but what judge is citing to see if it's actually what he's claiming. Okay? So, let's go.
After the April 11th incident, Levesque began receiving derogatory and threatening emails and phone calls from persons who learned about the incident and the student's suspension. Levesque submitted 75 emails to the district court, 69 were written after the Fox and Friends cablecast. Several were written during the hours that the cablecast ran, and while the defendants suggest that no email specifically mentioned Fox, at least one does. 3. In the action below, Levesque challenged 6 statements by the defendants. On appeal, he has elected to press his claims with respect to only 5. Therefore, we omit reference to the statement which Levesque does not raise on appeal. -7. Have got to learn that H.A.M is not a toy. Finally, Levesque disputed the defendant's assertion that the superintendent says it's akin to making these kids feel like they're being shot at back in Mogadishu and being starved to death. The defendants moved for summary judgment, contending that the statements were not defamatory and alternatively, that Levesque, who stipulated that he was a public official, could not show that the defendants acted with actual malice in making them. The district court held that the statements were protected on multiple grounds. Levesque vs. Ducey, 557 F. Sup. 2D 157, D.Me. 2008. It found the reference to hate crime substantially true, and the anti-H.A.M. hyperbole, response, plan, quip, protected, rhetorical. The court determined that the references to H.A.M. sandwich, the H.A.M is not a toy comment, and the Mogadishu statement were materially false, reasonably susceptible of a defamatory meaning, and highly offensive for purposes of the false light claim. Nevertheless, the court granted the defendants' motion, concluding that Levesque failed to produce evidence that the defendants acted with constitutional malice when making the statements. 2.
He cited to a case where the guy failed to make the burden?
2. Summary judgment is proper where the record shows no genuine issue as to any material fact, such that the movement is entitled to judgment as a matter of law. -8. Fed. RCIV. P. 56, C. C. Hahn vs. Sargent, 523 F2D 461, 464, 1st CIR. 1975. We review a grant of summary judgment de novo, FIACO, 528 F3D at 98, and thus conduct an independent review of the entire record, Bose Corp. versus
What it means when Karen and Aidan get the review of the anti-slap dismissal de novo. They review the whole record.
Although we view the record in the light most favorable to the non-movement, Hahn, 523 F2D at 464, we will reverse the grant of summary judgment only if the non-movement, here Levesque, produces evidence from which a jury might return a verdict in his favor. Anderson vs. Liberty Lobby, Inc., 470. This evidence must be substantial, Hahn, 523 F2, omitted, and go beyond the mere allegations of the complaint, c. A mere challenge to the credibility of a movement's witnesses without any supporting evidence does not raise a trial-worthy issue of fact. Favor 1988, T. He plaintiff must produce sufficient evidence supporting the claimed factual dispute. To require a jury or judge to resolve the parties' differing versions of the truth. Trial. Under Maine common law, a plaintiff alleging defamation must show a false and defamatory statement published without privilege to a third party resulting in harm to the plaintiff. Lester vs. Powers. 596. Me. Of. Public. Officials. Like. Levesque. Constitutionally protected. Breathing. Space. In. Discussions. A.2d. 65. Meanwhile. A. Society and thus are subject to a conditional privilege that is overcome only by clear and convincing evidence that the defamatory statement was made with actual malice. In other words, with knowledge that the statement was false or with reckless disregard of whether it was false or not. This actual malice standard can have profound consequences on the outcome of a defamation case, Mandel vs. Boston, 2006, with many deserving plaintiffs, including some intentionally subjected to injury. Unable to surmount the barrier of the 4. We are not unmindful of this circuit's recent defamation decision in Noonan vs. Staples, Inc., No. 07-2159, 2009 WL 350895. February 13, 2009, which found a genuine dispute on actual malice and held that the district court erred in granting summary judgment. However, Noonan applied Massachusetts common law on actual malice, defined as malicious intention, id. At *5, citing Connor vs. Standard Public Company, 183 Mass. 464, 1903. Here, we deal with actual malice in the constitutional sense. Additionally, the plaintiff in Noonan was neither a public official nor a public figure, and the defendant did not timely argue that the issue was a matter of public concern or that constitutional protections should apply. See id. At *5, n.7. Thus, the reasoning of Noonan is inapplicable to our analysis here.
Wait a minute! What has Judge done here? He's citing to a case. So here's the problem. When you cite to a federal court case, it's not normally binding unless it's a question of federal law. Judge has just cited to the case we're reading right now, the Levesque case, which is a constitutional question of the meaning of actual malice, not under Massachusetts law, but under not just Maine law, but the federal constitutional question raised under NYTV Sullivan. Oh boy, I wonder where he pulled this quote out of that he used in the holding right here. This thing. Deliberately ignored evidence that called into question published statements, and then thus plausibly suggesting recklessness amounting to actual malice. I wonder where that came from in this holding. Oh boy. Uh-oh.
-10. Times test, Gertz vs. Robert Welch, Inc., 418 U.S. 323, 342, 1974. Moreover, the substantive evidentiary standard of proof for actual malice applies at the motion for summary judgment stage. Anderson, 477 U.S. at 252. Thus, Levesque must provide evidence of actual malice with convincing clarity. New York Times Company, 376 U.S. at 285-86, to survive the defendant's motion for summary judgment.
So we're now looking at a preview of the 56F motion that's going to come up for summary judgment, which is even more tough for the H.A.M plaintiffs here. But, I mean, what is going on with Judge here?
Squarely within this legal framework, we first examine the challenged statements to determine whether the district court erred in holding defamatory, some non-actionable, and others potentially. Because with one caveat we ultimately agree with the district court's findings, we next consider whether the defendants acted with actual malice when making the defamatory statements. Point 5. A. Defamatory in nature. The district court held that a jury could find defamatory the defendant's attribution to Levesque of two false and absurd quotations, "H.A.M is not a toy," and "it's akin to making these kids feel like they're being shot at back in Mogadishu and being starved to death," along with repeated references to a sandwich, which included a recreation of the incident. Found that the defendant's statements that the court, Levesque, Lewiston Middle School considered the incident to be a potential hate crime, and the use of the term anti-H.A.M response plan were not defamatory, concluding that the former was substantially true, and the latter was rhetorical hyperbole. A communication is defamatory if it is provable as false. Milkovich vs. Lorraine Journal Company tends so to harm the reputation of another as to lower him in the estimation of the community, or 2. Associating or dealing with him. Deter. 3rd. 1990, quoting restatement, 2nd, of torts sec. Whether a statement is susceptible to a defamatory meaning is a question of law. To appropriately construe the statement, what, in the light of, might reasonably have been understood therefrom by the persons who heard it, via 1993, a court should consider the context in which the challenged statement is made, viewing it within the communication as a whole. Amarak prods.
Not what Judge did with Aidan's statement.
We dispense first with those comments which the district court found non-actionable. A substantially true statement does not provide adequate basis for a defamation claim under Maine law. Lewiston Middle School classified the offending student's conduct as hate crime bias in its computer system. Both the Washak and Plagman articles accurately quoted Levesque describing the conduct as a hate incident, and the Washak article opened with more disciplinary action could follow. A possible hate crime at Lewiston Middle School, Superintendent Leon Levesque said. We therefore agree with the district court that he defendant's statement, he superintendent and the school board are looking into perhaps other charges against the kid because it's a hate crime, is not actionable because it is substantially true. We also agree that the defendant's references to an anti-H.A.M response plan were not defamatory statements that contain imaginative expression or rhetorical hyperbole are protected. Here, the defendants augmented Washuk's accurate reporting. The center is working with the school to create a response plan with Plagman's creative flourish. The center is working with the school to create an anti-H.A.M response plan. This loosely rhyming phrase provided the defendants with a succinct, perhaps distasteful, jingle through which to express their derision, but such a device does not qualify as a provably false statement, capable of a defamatory nature. Further, it cannot reasonably be interpreted as stating actual facts about Levesque. We turn next to those statements which the trial court found defamatory in nature. The defendant's repeated references to a ham sandwich, Levesque, and 2 fabricated statements attributed to, while the district court found that the defendant's mischaracterization of the ham placed on the Somali student's table presented a jury question as to whether the remarks were defamatory in nature. We think it is a close question whether the references to a ham sandwich would have a different effect on the mind of a listener than an accurate report about a leftover ham steak. See Masson, 501 U.S. at 517. However, because our ultimate 6. Alternatively, resolution of this case makes such a determination unnecessary, we do not disturb the district court's findings. We concur with the district court that a jury reasonably could conclude that the 2 fabricated statements attributed to Levesque were defamatory. The Supreme Court has observed in general, quotation marks around a passage indicate to the reader that the passage reproduces the speaker's words verbatim. They inform the reader that he or she is reading the statement of the speaker, not a paraphrase or other indirect interpretation by an author. By providing this information, quotations add authority to the statement and credibility to the author's work. Quotations allow the reader to form his or her own conclusions and to assess the conclusions of the author, instead of relying entirely upon the author's characterization of her subject. He Attribution may result in injury to reputation, because the manner of expression or even the fact that the statement was made indicates a negative personal trait or an attitude the speaker does not hold. During the Fox and Friends cablecast, the hosts persistently ridiculed the Lewiston Public Schools and Levesque for the response to the April 11th incident and emphasized several times two false and particularly ridiculous quotations.
That's a great question, Kishka. It seems like at the motion to dismiss stage they don't. We're really looking into, though, whether Judge accurately pulled the precedent from this case to hold against Aidan. Aidan saying to Natalie that Karen's statement or bringing up Jen McCabe's 227 purported Google search didn't make sense in light of Karen's overall theory, although Aidan's position later changed. Is that enough to show that Aidan, with regards to Brian and Higgins and Brian Albert, completely disregarded the potential that false information from his source Karen was staring him in the face? And the judge, Gildea, cites to this case Levesque, which first of all is about New York Times Covey Sullivan being applied in the context of Maine common law, but it's a constitutional question. So it's being analyzed not from the perspective just of Maine common law, but New York Times Covey U.S., which is a U.S. Supreme Court case from 72 about the standard for actual malice when suing a public figure. Everyone understand? And we're trying to figure out where Judge got this idea that Aidan, talking to Natalie and saying he had questions about Karen's theory in light of 227, somehow fits in with a grant of an affirmed appellate, like an appeals court affirming a grant of summary judgment in a defamation case in favor of Fox News involving a ham sandwich in Maine.
Several times two false and particularly ridiculous quotations, which they attributed to Levesque. Ham is not a toy, and a comparison of the incident to Mogadishu. The attribution of these comments to Levesque, coupled with the defendant's laughter tinged with contempt, Powers versus Durgan Snow, 1958, encouraged viewers to form negative conclusions about Levesque, thus tending to harm his reputation. Therefore, we agree with the district court that a genuine issue of material fact exists to whether the statements were defamatory. Point 7.
Now here's what we want.
B. Actual malice. A public official advancing a defamation claim must show that the challenged statement was made with a high degree of awareness of probable falsity. Bose Corp. 692 F2D at 195. Internal quotations and citation omitted. In other words, the defendant must act either with actual knowledge of the falsity or with reckless disregard for the truth. New York Times Company, 376. U.S. is at 279-80. Actual. Reasonably. Prudent. Connaughton. 491. Malice. Conduct. U.S. Industries. Levesque does not suggest that the defendants actually knew the Plagman article provided false information. Thus, he must show sufficient evidence to permit the conclusion that the defendant, S., in fact entertained serious doubts as to the truth of the Plagman article and the statements it attributed to Levesque. Id. Because direct evidence of actual malice is rare, it may be proved through inference. Bose Corp. 692 F2D at 196, and 7. Similarly, a jury reasonably could conclude that the statements met the highly offensive to a reasonable person element of the main false light cause of action. Recklessness amounting to actual malice may be found where a publisher fabricates an account, makes inherently improbable allegations, relies on a source where there is an obvious reason to doubt its veracity, or deliberately ignores evidence that calls into question his published statements. 684-85, Saint Amant, 390 U.S. at 732. Connaughton, 491 U.S. See Hunt vs. Liberty Lobby, 720. F.2d 631, 643, 11th CIR. 1983, finding actual malice where the investigation was grossly inadequate, the story was not hot news, and the neutrality of the source was dubious.
Okay, so the investigation couldn't have been... Are you telling me the actual standard is whether Aidan did a grossly inadequate investigation, whether the story was hot news, and whether Karen was neutral? Are you kidding me? God.
Noting that a court should consider the thoroughness and methodology of a publisher's preparation and the expertise of its authors, but see Saint Amant, 390 US at 733. Failure to investigate does not in itself establish bad faith. 1996, actual malice may be inferred from an author's or publisher's inability
Oh, wait a minute. Hold on.
corroborate. Failure to investigate does not in itself establish bad faith. McFarlane vs. Sheridan Square Press, Inc., 91 F3D 1501, 1511, DCCIR. 1996, actual malice may be inferred from an author's or publisher's inability to corroborate a story only when, in attempting to corroborate, he encounters persuasive evidence that contradicts the allegation.
Oh my
Levesque
God.
contends that the defendant's failure to corroborate the fabricated quotes from the Plagman article coupled with incredulous statements during the cablecast, e.g., "I hope we're not being duped," and "I thought this was a joke," establish that the defendants acted with reckless disregard for the truth. -17. He notes that Fox rushed to broadcast the 2-week-old story even though it was not breaking news. See Curtis Pub. Co. vs. Butts, 388. US 130, 157, 1967, Hunt, 720 F2D at 643. It is true that a more deliberate consideration of the Plagman article should have caused reasonable defendants were skepticism, careless in about the relying on source 8, it, and but indication of negligence, not actual malice, and superintendent.
It is true that a more deliberate consideration of the Plagman article should have caused reasonable skepticism about the source, and that the defendants were careless in relying on it. But this is an indication
of negligence, not actual malice, and superintendent. Levesque faces the heavy burden of providing evidence that the defendants recognized the carelessness with which they were proceeding. See Saint Amant, 390 US at 731. Our reckless conduct is not measured by whether a reasonably prudent man would have published or would have investigated before publishing. In preparing for the cablecast, the defendants authenticated the April 11th incident and various facts reported in the Plagman article through reputable sources. Compare to Valerius versus Pirro, 817 F2D 762, 790, DCCIR. 1987, finding no actual malice and agreeing with the district court's assertion that much of the unreliable sources' information was independently verified by other sources whose credibility even the plaintiff does not now. 8. In addition to those statements which challenge, with Cell versus Filipino Representative Enter. Inc., 209 F3D 163, 190, F2D CIR. 2000, finding actual malice where the defendants relied on a single person who had a known bias against the plaintiff and whose account had internal inconsistencies.
Okay, now you're getting closer to a relevant case. But even then, like, it's not just that, okay? You have to show that Aidan didn't do anything to, like, assuage his concerns. He, like, ignored it. He went and researched it more. Judge said that himself. But this, it's actually Cell vs. Filipino Rep Enter Inc. 209 F3D 163 at 190 pin site from the Second Circuit, where you find actual malice where the defendants relied on a single person who had a known bias against the plaintiff and whose account had internal inconsistencies. One, I don't think Aidan relied only on a single source. Two, like, that's not enough. That gets you only the first part of it. You also have to show that Aidan, like, ignored that. He didn't make any effort to remedy his understanding with the inconsistency or purported inconsistency. I'm incredulous. Now, it doesn't matter whether Karen's report to Aidan was unbiased. The standard, and Judge didn't even cite to this, but the case is actually Cell vs. Filipino Rep Enter Inc. Okay? That case had a situation where defendants relied on a single person who had a known bias against the plaintiff and whose account had internal inconsistencies. That's not even what we're dealing with Karen and Aidan, but that's closer to what Judge was trying to say than what he cited, because the case he cited is not what he wanted. It's bad. He completely swung and missed so far, and we're almost done with it.
In the present case, the two actionable statements attributed to Levesque were certainly absurd, but the Plagman article presented them within larger, accurate comments that could be corroborated with the Washak article, 1980, as long as the sources of the libelous See Ryan vs. Brooks, 634 F2D 726, 734, 4th. CIR. 1980, as long as the sources of the libelous information appeared reliable, and the defendant had no doubts about its accuracy, the courts have held the evidence of malice insufficient to support a jury verdict, even if a more thorough investigation might have prevented the admitted citations.
Error! Oh my God! As long as the sources of libelous information appeared reliable and the defendant had no doubts about its accuracy, the courts have held the evidence of malice insufficient to support a jury verdict. That means insufficient to reach trial, although this is summary judgment, even if a more thorough investigation might have prevented the admitted error. Aidan didn't even make an admitted error. He just had questions that then he looked into more. Oh God.
Incident was not hot news. 9. But Levesque has offered no evidence that the defendants deliberately limited their investigatory inquiry point. Nonetheless, the Fox and Friends show was more timely than the defamatory articles in Hunt, published in 1978 about the plaintiff's possible involvement in the 1963 assassination of President John F. Kennedy Jr., 720 F2D at 634-35, and Curtis Pub Company, written in March 1963 about a September 1962 event involving the plaintiff. But we acknowledge that the case law which instructs our inquiry does not include situations in which defendants relied on internet sources, a more recent but undoubtedly commonplace practice today. While publishers should employ greater caution with those internet websites that do not go through the vetting process of traditional.
Hold, please.
News media, reliance in part on an internet posting does not necessarily change our legal analysis. See Zeron vs. Diamond. Broad, Inc., 203 F3D 714, 719, 10th CIR. 2000, employing traditional false light analysis and determining that defendant radio show host's reliance on an anonymous and ultimately false internet posting to urge listeners to harangue plaintiff did not qualify as actual malice. 11.
Wow. Okay. Wow. This summary judgment battle, if it gets that far, is going to be fascinating.
During discovery, the defendants and other Fox employees consistently stated that they believed the Plagman article was reliable, both because it cited the App 11 and because they corroborated many of the article's facts with other sources. Connaughton, 491 US at 684 to 85. Defendant deliberately ignored available evidence to the point of avoiding the truth. Hunt, 720. F.2d at 645 to 46. Defendant had reason to question the neutrality of sources and the entire premise of the
Story was
inherently improbable. Norris versus Bangor Pub Company. Defendant ignored pertinent and contradictory information supporting an inference that he possessed a political motive of publishing the story. News media reliance. None of the Fox employees were familiar with associated content when they discovered the Plagman article, but they consistently indicated that they found relevant its citation to the app. In fact, several, including Ducey, stated that they believed the Plagman article actually was an app piece. In his deposition, Levesque's expert recognized the AP's reputation for reliability and noted that it was one of two sources he regularly used. Still, we agree with the expert that he discrepancy between an associated content piece and an app piece should have been spotted, but where, as here, the plaintiff has failed to produce additional evidence of a defendant's subjective recklessness, this oversight establishes only negligence, not actual malice. -20. To rebut these assertions, Levesque emphasizes Ducey and Kilmeade's statements during the cablecast expressing incredulity as evidence that the defendants harbored doubts about the veracity of the quotes. In certain contexts, a statement like, "I hope we're not being duped," likely would raise a genuine issue of material fact on the question of actual malice. See Hunt, 720 F2D at 638. Finding relevant for actual malice purposes the fact that an editor wrote, "Confirm this," for a certain section of the novel's draft, but in the context of a consistently irreverent, and too many, insensitive, morning television show. See Selig vs. Infinity. Broad Corp. 97 Cal. App. 4th 798, 811, 2002, noting that the irreverence of the morning radio program, which may strike some as humorous and others as gratuitously disparaging, is not atypical of this genre. Such statements frequently are used as devices to magnify the presentation and grab viewers' attention. See e.g. Depp of Brian Kilmeade, 67, 17 to 23, 68 to 37, January 16, 2008. I am trying to let people know that this is a story you should pay attention to. I mean, wake up. I know you're brushing your teeth, putting on your pants, getting ready for school. I just want to make sure people watch on a regular basis. Tease stories, you get people's attention. The district court. We thus agree with the district court that these statements do nothing to undermine. -21. The defendant's sworn testimony regarding their belief in the veracity of the Plagman article. 12. Beyond noting the ridiculous quality of the fabricated quotations and Ducey and Kilmeade's statements of incredulity during the cablecast, Levesque offered no additional evidence, let Alone any of convincing clarity, New York Times Company. 376 US at 285 to 86, to show that the defendants disbelieved or entertained serious doubts about the challenged statements in the Plagman article, an evidentiary burden required of the summary judgment. Stage, Anderson, 477 US at 252. The defendants were negligent in their failure to question adequately the reliability of the Plagman article and conduct further research before attributing the outrageous quotations to Levesque. Unlike the district court, we hope that this conduct was an extreme departure from professional standards. Connaughton, 491 US at 665. That the negligence was accompanied by derisive contempt and ridicule directed at Levesque makes all the more distasteful the defendants' carelessness. But while the defendants reported as true false statements, they did so after verifying the underlying facts of the April 11th incident. Their vetting process was perhaps too cursory and perfunctory, but no facts indicate that the defendants purposefully avoided the 12. We also observe the truth, and we think the substantial truth of the story which they reported obviates a finding of actual malice. See Saint Amant, 390. US at 731, it may be said that the actual malice test puts a premium on ignorance. But to ensure the ascertainment and publication of the truth about public affairs, it is essential that the First Amendment protects some erroneous publications as well as true ones. The actual malice standard, adopted to ensure a vibrant media check on official action, requires more of Levesque to survive summary judgment. Certainly, as we noted above, it exacts a high price from the victims of defamatory falsehood. Plainly, many deserving plaintiffs, including some intentionally subjected to injury, will be unable to surmount the barrier of the New York Times test. Gertz, 418 US at 342. This action reminds us that in a court of law, sympathy does not always to the victor go. We find that Levesque cannot survive the defendant's motion for summary judgment. Point 13. 3. For the foregoing reasons, we affirm the district court's grant of summary judgment. 13.
That's wild. That's wild. Absolutely wild. Okay? That case is so sympathetic to Aidan and Karen's position. When you ask, why does this happen every time? It can never just be a straightforward ruling. It always has to be some just completely mangled interpolation of the standard. And it applies it completely incorrectly. This case is actually a strong case in defense of someone who publishes, even without like a valid process, like a piece of information or relays it to a third party. Oh my goodness. And judge cites it for the proposition. This happened again. It has happened again. That's why you can never just take these rulings on their face. Judge cites it for the proposition that Kearney deliberately ignored evidence that called into question his published statements, and that such allegations plausibly suggest recklessness amounting to actual malice. That is not what Levesque versus Ducey stands for. At all. Not even close. Not even on the same, planet. How do I know? I read it. Every word of its 23 pages. I've read it so well that I know that where this standard actually comes out of is a combination of Connaughton, 491 US at 684.85, and Hunt, 720 F2D at 645 to 646. Dude, I have serious questions right now about whether Judge Gildea actually read that opinion. And this is not the first time this has happened. Oh my God, not again. It's just, sometimes you hunt it down, you actually look at the case, and you're like, okay, it's not really like what I think the court ruled, but I see where Judge got it. I see where he was like going. No, not on this one. No, that's wrong. That is not, I'm just telling you. Listen, I am not a lawyer, but I did go to law school, and this is not legal advice. That is wrong. That is not, first of all, Levesque versus Ducey actually helps Aidan and Karen. Mostly Aidan, because this is about Aidan's MTD. Second of all, it's about a motion for summary judgment, not a motion to dismiss under 12b-6. Third of all, those quotes do not come. Levesque versus Ducey is the appellate court in the federal district, in the First Circuit, affirming a grant of summary judgment for some reporters who printed false quotes attributed to the superintendent of a school in Maine about a ham sandwich. Shout out H.A.M. He's wrong. He's wrong. He's not just wrong. This indicates passive indifference, and I'm being generous, to the case. Because that's not what it stands for. Not even close. Not even in the same ballpark. There are cases within there. I can show you both of them. CF v. Connaughton, okay, which is Hart Hanks Combs v. Connaughton, okay. That stands for one of those propositions, which we now have to review. But he got the case wrong. And then the Hunt case, okay, which is a fascinating case, okay, about, I think it involves E. Howard Hunt, all right? That is closer to what Judge was going for, as is this case, okay? So this case, Connaughton, is a little bit closer, okay, as is the E. Howard Hunt v. Liberty Lobby. This case, Levesque versus Ducey, cuts against everything Judge just said. Every bit of it. Are you kidding me? These lawyers must be losing their ever-loving mind. And I know, I didn't even realize Attorney Little was going to analyze this too, so I'm so sorry about that. And by the way, my streams take a long time. If you're new to these, we do read the orders, but what we do is we treat it with trust but verify. If a judge is going to quote a case, especially Judge Gildea, what we'll do on this stream is actually go to the case. And inevitably what that leads us into is other cases. Now in this situation, what really bothers me is Judge got this completely wrong. Completely wrong. He got the Ducey case wrong, and I'm pretty sure if we actually, so to correct him, I'm a little bit worried that this is an AI summary. I'm not even sure a clerk did this, because if you were a clerk and you did your homework, that's not how you would summarize Levesque v. Ducey. An AI might pull that out and then pull this out and attribute it to Ducey, but that's only because it's misunderstanding that Connaughton and Hunt are the actual cases where this statement and this statement come from. Are you kidding me? Dude, the reason I'm apoplectic about this, I want you to understand, sorry for the frame drop. The reason I'm apoplectic about this, I want you must understand. So we just did that exercise together. Would you summarize the Ducey case as standing for the proposition that someone who deliberately ignores evidence that called into question his published statements indicates that such allegations plausibly suggest recklessness amounting to malice? Dude, no. No. This is absolutely not okay. And I don't mean not okay. Listen, I need to just breathe because I'm going to get really mad about this. This is not okay. This is so serious as we need to bring Judge Erskine in and have her double check this, because if Judge Erskine reviews this, she would never, I imagine, criticize a sitting justice. But if she reads this and says the same thing I did, then this is AI. or at least the person who generated this citation did not read the underlying case. Here's what makes me really mad. I could disagree with a judge about a conclusion of law. You can read a case, two different people can read the same case the same way, Levesque v. Ducey, and come up with two different opinions about whether, like, the motion for summary judgment was appropriately granted by the appellate court, okay, and appropriately affirmed by the appellate court. Where this gets into, like, I'm worried this is AI territory, is, and this is so scary, the fact that this, and I don't mean scary compared to some of the cases we've covered, it's scary because judges can't be doing this. What makes it potentially AI is, listen, I tore that Levesque v. Ducey case apart. You just saw me do it. I went through every single part of it. Those quotes don't come from Levesque v. Ducey. Nor does Levesque v. Ducey stand for those quotes. They come out of two completely different cases and have nothing to do with the holding in Levesque v. Ducey, which is actually more favorable to Aidan and Karen. Which means, and which is what is shocking, is that Levesque v. Ducey is being inappropriately cited for standards that it does not reflect, certainly not in the way Judge is implying here, instead of citing to Connaughton and Hunt. This is really not okay. This wouldn't be okay from a first-year law student. I would be furious. It doesn't have the style of AI, but the summary of that case is just wrong. That is a judge. And this is serious. This is not as serious and weighty as some of the disclosures we've covered about crimes. This is just a matter of judicial integrity. He's wrong, and the citation, the quotes he's pulling out, one, do not reflect Levesque v. Ducey, and two, come from cases quoted in Levesque v. Ducey. That's classic AI. Oh, jeez. He can't do this. I'm just telling you. Listen, I gotta call. It's not fair. The judiciary is a branch of the government. And I can't sit around worried about whether I'm going to get retaliated against for calling it down the middle. Alright? He can't do this. He can't do this case. I'm just telling you. It's too much. The workload is too much. The facts are too much. And he's taking shortcuts. And it's hurting my state. Okay? Pull him off it. That's my opinion to the government. Pull him off it. This is getting worse, not better. Do you want the appellate court to write an opinion? Do you really want them to write an opinion about this? Because they're going to be mad. This can't happen. And again, this is not an ideological dispute. I understand the Ducey case. First of all, it helps Aidan and Karen. Okay? Fox won. Okay? And the actual malice standard, literally, Ducey ends by the court saying, let me just read you the end of Ducey so I can tell you how freaking incredulous I am right now. Ducey ends with the court, this is what Judge cited to justify his key prong of why Aidan's statement to Natalie about Aidan's confusion about the 2:27 a.m. search means that he had actual malice towards Brian Higgins, and Brian Albert. Quote, the actual malice standard adopted to ensure a vibrant media check on official action requires more of defendant Levesque to survive summary judgment. Certainly, as we noted above, it exacts a high price from the victims of defamatory falsehood. Plainly, many deserving plaintiffs, including some intentionally subjected to injury, will be unable to surmount the barrier of the New York Times v. Sullivan test. Gertz, 418 U.S. at 342. This action reminds us that in a court of law, sympathy does not always to the victor go. That's what Levesque v. Ducey stands for. We find that Levesque cannot survive the defendant's motion for summary judgment. Get out of here. Get out of here. Hello, T.A. Sarah. 50 billion bonus points for being a T.A. Sarah. That's it. I'm worried that he's not just wrong. I'm worried that he's using AI. I'm sorry. Listen, Judge Krupp was in the frickin' Epstein files too, and he hates me now. But it is what it is, Brett. All right? I can't control what you did. Okay? You did it. I found it. You did it. I just found it. This is absurd. This is actually like a... I have to calm down because I'm going to get made. Legally, this is a problem. And we need to, like, we might actually have to bring in the Judicial Tenure Commission. Because this is not, like, a lawyer would get sanctioned for doing that. This is not just having an opinion about a case that is, you know, arguable. You're looking at the appellate court's interpretation of the statute, you're quoting to it. You say, all right, you know, like, Judge, that was like what they were going for, but like the way you argued it is like it kind of takes the court's conclusion and it like takes it out of context a little bit. Like, I see where you were going, but like I'm not really sure that's what the appellate court was trying to say. This is worse. Something like that I would have just moved on. I would have been like, you know what? Like I like it's not the strongest argument, or it's a strong argument, or it's debatable. That you would not hear me actually upset about. What I am upset about, and this is a big deal, I know a lot of you will be like, Grant, how did you even pull that out of there? Well, I showed you how I did it. I read the freaking case. I took however long, I don't even want to know, and I sat there. You did too. And looked at the reward you got out of it. You can now look at this statement, which looks innocuous, from Judge. This is not Judge summarizing, by the way, facts. It is Judge citing to the central authority of law for his decision about why Aidan acted with actual malice. It is the key point of that entire section of the ruling. And he didn't just get it wrong. That would be one thing. I'd be telling you, like, listen, it's arguable. Everyone could have a different opinion. He didn't just get it wrong. He cited quotes incorrectly and attributed them to a case that does not stand for either proposition, but instead reflects the court analyzing a test from respectively, what is this one called? Connaughton. And the first part, deliberately ignored evidence that called into question his published statements. And then it also blends in the Hunt test from Hunt v. Liberty Lobby, recklessness amounting to actual malice for doing so. Ducey is the opposite. Ducey does not find actual malice. In fact, they say the actual malice standard is so hard that it throws many a deserving plaintiff out of the court. In fact, it says, this action reminds us that in a court of law, sympathy does not always to the victor go. Our sympathies. The judge cited it as a reason for Aidan having actual malice. He got it wrong. He got it completely wrong. And he summarized the case in a way that strongly leads me to believe he used AI to do it. Listen to me. If I were teaching a law school class and one of my students did this, I would bring them to the dean's office. I would sit them down and I would say to me, you are going to sit here with me and the dean and you are going to tell me exactly how when you read Levesque v. Ducey, you determined that it stood for the proposition that someone who deliberately ignores evidence that calls into question his published statements and, quote, does so in a way that amounts to recklessness, tantamount to actual malice. How you got that from the Levesque v. Ducey case? I would sit there and I would say, firstly, student, what does the Levesque v. Ducey case stand for? What happened? What did the appellate court rule? If the student said they affirmed summary judgment, I'd be like, all right, well, at least you read it. Affirmed a grant of summary judgment. And then I would say, okay, and by doing that, what did the court say about the actual malice standard? What did they say? How high is that burden? Did the court anywhere in Ducey say that Kilmeade deliberately ignored evidence that called into question his published statements and then held him accountable for it in a way that was considered actual malice? Point me to the line. Point me to the line in the decision where they said that. And then I'd say, you can't. Isn't that right? They probably would have not got the summary judgment question right. And I would have been like, they'd be sweating at this point. I'd be like, you used AI, didn't you? Didn't you? Tell me, didn't you? What does the Hunt case stand for? Oh, you read Ducey? What does the Hunt case stand for? Why is Hunt important in Ducey? Why is New York Times v. Sullivan controlling in Ducey? Not okay. I want to know what Attorney Little thinks. I want to know if she sees this. See, the thing is, you wouldn't. Here's why I have to do it this way. On the surface, that sentence looks plausible to a lawyer or to a judge. It really does. When Kearney, quote, deliberately ignored evidence that called into question his published statements, such allegations plausibly suggest recklessness amounting to actual malice. Cite Levesque v. Ducey. But that's not what Levesque v. Ducey stands for. At all. At all. 50 billion bonus points for T.A. Sarah for being so supportive. She's the T.A. She's so smart. Listen, once I can chalk it up to a clerk. Twice, no. Either we got a clerk who doesn't know how to read, or is exceptionally lazy, or used AI, or we got a judge using AI. I'm telling you, trust my gut here. Just trust me. That's not what a lawyer or a law student or a clerk or a judge would write if they read Ducey. Just please trust me. So actually, you know what? Will someone do me a favor? Can someone go into Attorney Little's chat in a friendly way, obviously. We love the cupcakes. And can someone just say, listen, Attorney Little, Grant just read, it's page 9 of 16 in Judge Gildea's ruling, and he's at the end of the first paragraph, the end of the paragraph that starts on page 8, goes into page 9. And he's reading the last sentence, and he's wondering if he thinks it's very important that you read Levesque v. Ducey, 560 F3D 8290, the First Circuit 2009. And then tell her the reason why he says, somebody, T.A. Sarah, I don't know, somebody take notes. Tell her the reason why Grant says it's so important is because if you read Levesque v. Ducey, it doesn't stand for the propositions that Judge Gildea cites it for. And then furthermore, tell her New York Times v. Sullivan is controlling in Levesque v. Ducey. And then also tell her in Levesque v. Ducey, the motion for summary judgment was actually granted in favor of the defendant in a defamation action. Then tell her also that the two operative cases outside of New York Times v. Sullivan in Ducey that the quotes actually come from are, and you got to be specific with this. Okay, the first one is, you can also tell her to just like rewatch my stream from 5 minutes before, and I'm sure she can look this up. Hart, Hanks, Combs versus Connaughton, 491 US 657, which she's going to find in Ducey. And then also E. Howard Hunt v. Liberty Lobby from the 11th Circuit, 720 F2D 631 in 1983. If she actually, just tell her, this is very important, because I need if she confirms what I'm saying, and it's only worth it to do it if you're already reading the decision. So when she gets to page 9, somebody stop her at the top, if you wouldn't be so kind, and just say, you know, it's 23 pages, but it's worth it. You should read Levesque v. Ducey, and just don't take Judge Gildea at his word on that. Read the case, and then look at what it stands for. And then if she's like, wait a minute, I know it's going to take her like an hour, but it's worth it, because she's going to find that this is potentially an AI generated citation. Don't tip her off though. Don't you tell her the conclusion, because then she'll have confirmation bias. Just tell her you want to read Levesque v. Ducey. Tell her it's not an exercise in futility. All right, everybody get the notes? I think I've told enough of you now. Don't let her just skip over that, because I have to know. I can't impact her analysis. She can't skip over that line, because this isn't some throwaway citation. It's a very, very important part of the ruling about whether, by Aidan talking to Natalie about the 2:27 a.m. Google search timestamp, whether his initial questions about that demonstrate actual malice, which it doesn't. And that is the key case on which Judge Gildea's entire ruling turns. Okay? All right? Judge Gildea makes like some procedural arguments after that to kind of like reject Aidan's like larger contextualized framing of his investigative efforts regarding the statement he made to Natalie and like how the 2:27 a.m. search played into Karen's theory. But I'm telling you, if she does it, she's going to find, I think 95%, that this quote is an AI-generated, hallucinated citation. It's fake. I'm telling you. I promise you. Rosenberg would... I don't know. I bet Rosenberg would find it. I bet... what's his name? David Seligson would find it. I bet Alan Jackson found this too. Because none of them would just skip over it. They've learned that he does this. But this is different. This is so egregious, so bad, so wrong, as to literally undermine the entire ruling, at least on this section, because that's the most important part, the actual malice standard, and that is not the way you reach it, and that is not the case to cite for it. And listen, you can get actually sanctioned. I don't know what the hell the JTC would do, but you can't do that. And no one, what's so slimy about it, which makes me so mad, is no one ever would have caught that unless they read or were familiar with that Levesque v. Ducey case. And unless they actually went through and read the whole thing. It would just look like a reasonable citation. My God. And the thing is, I don't think this is Judge Gildea being like in on an op or what. I think this is pure laziness. I think he doesn't like Aidan and Karen, and he's being lazy. Gildea, hi, Jackson's Unleashed. Listen, this is actually wild. I can't believe this has happened again. And listen, mark my words, if Attorney Little, I bet people went over there and were like, hey, you know, this is very important. If she feels the same way, we got him. I can't, like, I'm one person. So I know I'm right, but I want to hear another lawyer. I'm not a lawyer, but I did go to law school. I want to hear a lawyer weigh in on this, because I think they're going to tell you the same thing. We might have just caught him. I think some of you may not understand how big of a deal this is. I know some of you are onto it. This might be what's called a hallucinated citation. Wow. Oh my God. That's a big deal. Fuck. Dude, that would sink him. I'm telling you, if we can prove this is hallucinated, he's off the case. You might think we can prove it. That's a fake citation. Oh my god. Normally I wouldn't be so apoplectic, but I'm telling you, I've been around. That's a hallucinated citation. Game over. He's done. I'm not a lawyer, and I'm not a lawyer on the case, but if they confirm that is a hallucinated citation, he's done. Holy shit. Dude, you know this stuff's going to get torn apart. How are you going to get it so wrong? Oh my god. Dude, this is a terrible feeling. This is a gross feeling. I can't even believe it. Yeah, we probably should ask brother counsel too to look at this. I actually need a second opinion. I'm gonna write it up, and then we'll see if brother counsel can weigh in. I need like just another like a lawyer who they need to know this case very well, and they gotta have no bias. They gotta like they just gotta be able to read it and like pull themselves back and tell me if that's hallucinated. If it is, like that's it. We're done. That actually ends the analysis of the ruling because it's fake. You can't have a hallucinated citation as a key crux of a major part of the ruling. You can't. It's a huge scandal. But I want to hear a lawyer say it. I want to hear Melanie Little or brother counsel or I just want to hear a lawyer say it. If I hear one of those lawyers say it, I'll know I'm right. And I'm going to stay on until one of them can review it. So let me write this up. Are you fucking kidding me? What are we, if this is true, what are we supposed to tell the law students? Dude, this is a high profile case. What, did he think no one was gonna see this? Did he not even read it? I mean, what the fuck? I'm sorry for cussing, but seriously, I am so upset right now. And I'm not just guessing. You all saw me. I read that case. I know what I'm talking about. Oh, I am getting more upset the more I think about this. I'm going to play a song, and I'm going to write this up before I get really upset. And this was one of the other cases cited in Levesque, Saint Armand. Can we dance to Run? Yes. Motion to listen to Run approved. I absolutely am down with that. You know what I'm saying? Motion approved. I have thus approved the motion. You heard them. Take it away, DJ Tao. You know what to do. Yeah, you do. Let's do it. I'm mad. Where's the next song? What are we doing here? How am I supposed to write without rhyming? Thank you. Good song, but to write this one up, I'm gonna need more music. This is a tough one to write up, but it's for lawyers to read, so I gotta write it up in a lawyer way. We're doing an Arabic song time today, and let's go, T.A. Arabic. No, not a prof song. I want this song. Let's go. Oh, yeah. Listen, this is how all people who go to law school do their studying and work. Don't let them tell you otherwise. They sit around and they dance to Arabic music in front of hundreds of people and write up stories on Twitter. That's what lawyers do. I'm not a lawyer, but I did go to law school. Oh, and then they accuse judges of hallucinating case citations after reading the cases embedded within the judge's order because they don't trust the judge. Hi, Mimi! Take that, Massachusetts judicial system! Making me all mad! That was a good song. What do we got next? I need something very upbeat. You're gonna have to keep me going. You know what I'm saying? I got more writing to do. You know what I'm saying? What are we gonna do here? All right. What do we see? I need something that's Ooh, I like this song. Run it back. Let's go. This is way better than Matlock, admit it. Alright, now how about some German? How about some... Now we're going German, okay? That was a good song. We're gonna need another song though. I got a lot more research to do. Do you see what it's like to actually write a piece? So a lot of writers in the legal world, in like the legal like analyst world, rely on AI. I'm like, bruh, no, dude, you gotta do it. You just gotta do it. Oh, I got a song for all you out there, all you fans in Jolene recovery who can't watch Jolene because you're serious news presenters and then you start mocking everyone in the entire world. Great song. All right, what do we got next? See how much progress we make when we put a song on for Towel? We got to put a good song on, though. You know what I'm saying? All right. Here's a song for you. This really speaks to what I have in my soul.
I just need to get it off my chest. Yeah, more than you know. Yeah, more than you know. I saw it coming from miles away. I better speak if I got something to say, 'cause it ain't over unless you sing. You had your reasons, you had you, that I would see it in your eyes. I just need to get it off my chest. Yeah, more than you know, yeah, more than you know. You should have been the best. Yeah, more than you know, 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 yeah, I just.
Here's what else makes me think this is AI. This quote appears basically verbatim elsewhere in Judge Gildea's decision. Like basically verbatim. Watch. Look, he goes and finds a case, but because direct evidence of subjective belief really exists, a court will typically infer actual malice from objective facts. Lemonson, C. Edwards. And this court says, because direct evidence of actual malice is rare, it may be proved through inference. It's actually Bose and Connaughton. Alright? And then the actual standard, okay? So I have to do this whole thing. The actual standard is thus. I gotta go back to music, sorry about that. Got more work to do. Sorry about that. I got a lot of work to do to get this done. But, you know, you get to sit here and watch me work. Judge Gildea's golf. Oh, he does. Uh-oh. Uh-oh. Fine, we'll do it. I like this one. That was decent. Could have been better. Could have been better. I need to finish my research on one more part of this, so we have a little bit more to go. Alright? A little bit more to go. What else do we got here? How about this?
Yellow diamonds in the light. Now we're standing side by side as a shadow crosses what it takes to come alive. It's the way I'm feeling, I just can't deny. But I couldn't let it go. We found love in a hopeless place. 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 Shining light through an open door. Love and life I will defy. Turn away 'cause I need you more. Feel the heartbeat in my mind. It's the way I'm feeling, I just can't deny. But I couldn't let it go. Found love in a hopeless place. We found love in a hopeless place. We found love in a hopeless place. We found love in a hopeless place. Yellow diamond in the light. Now we're standing side by side as a shadow crosses mine. What it takes to come alive. It's the way I'm feeling, I just can't deny. But I couldn't let it go. Found love in a hopeless place. We found love in a hopeless place. We found love in a hopeless place. We found love in a hopeless place.
Boom. Alright, so it's a completely hallucinated citation. I've reviewed it 6 times. I would like some other analysts to confirm it, but I've looked at it 3 times now, and the actual standard that Judge was trying to cite to is actually Hart-Hanks Combs versus Connaughton, Hunt v. Liberty Lobby, and St. Amant v. Thompson. Because Ducey is an opposite and actually does not stand for any of that. And the cases, by the way, where that proposition does apply, where like you like recklessly disregard like someone, or like you take one source to the exclusion of all others, or like see contradictory information and ignore it, notwithstanding that the cases like Connaughton and Hunt and St. Amant are completely, it's just a different test. The test isn't what Judge, so that's really the core of this. The test under those cases is not and was never deliberately ignoring evidence that called into question his public statements. Nothing in Ducey stands for that. The only thing that's even close to that in Ducey is like the summary of those other cases, okay? Right? Which actually comes from Connaughton and St. Amant and Hunt. Okay? The standard from Ducey is recklessness amounting to actual malice may be found where a publisher fabricates an account, makes inherently improbable allegations, relies on a source where there is an obvious reason to doubt its veracity, or deliberately ignores evidence that calls into question his published statements. But if you actually read Ducey, he loses. Okay? And the cite for deliberately ignoring evidence that calls into question his published statements it's one part, okay, one part of an OR test, one part, and it's citing to Connaughton, okay, which is actually, and it's not just citing to Connaughton. What's really fascinating about this is it's citing to Connaughton and Saint Amand and Bose, but then it's saying, but see Saint Amand, and then also McFarlane, okay? Do you see what it's saying? Failure to investigate itself does not in and of itself establish bad faith. And then it also says what you're actually looking for with actual malice is where the investigation was grossly inadequate, the story was not hot news, and the neutrality of the source was dubious. And then you also have to look at the court has to look at the thoroughness and methodology of a publisher's preparation and the expertise of its author. None of which Judge did. Because that's not actually what Ducey just doesn't stand for. It never did, and it doesn't stand for the proposition that deliberately ignoring evidence that calls into question one's published statements means that you reached actual malice. In fact, it's not even close to what those cases are about, because if you're going to take that standard from Ducey, which, by the way, Ducey does not rule in the favor of the plaintiff, that the Ducey court in the appellate court rules for dismissal on the summary judgment. But if you're going to take Ducey to stand for this, which it doesn't, what you're actually trying to argue is that there is a test enumerated through Connaughton and Hunt and Bose and Saint Amand and McFarlane, which somewhat builds this sort of multi-pronged analysis of what it is to engage in actual malice when you are, in effect, like presented with a credibility issue, a reason to not trust your source. That's why I think this is AI, because it's so, even if it's so wrong, it has the words right, but what the actual legal test is, if you're gonna cite to Connaughton, which you're actually doing, and Saint Amand and Hunt and McFarlane, the actual test is so nuanced, and Judge did none of that analysis. He didn't look at whether the investigation was grossly inadequate. He didn't look at whether the story was hot news. He didn't look at the neutrality of the source or whether there was more than one source. He didn't look at the thoroughness and methodology of the publisher's preparation and the expertise of the author. And he didn't consider that failure to investigate alone does not establish bad faith. He didn't do any of this because I don't think he read the damn case. No human, no judge could read that and take from it that deliberately ignoring evidence that calls into question published statements is the standard. First of all, it's not the standard from Ducey. It's actually the court rejecting the superintendent's arguments, the plaintiff in the defamation action, for having met that standard. Okay, Ducey did not meet that standard. So if you're going to cite Ducey, it's for the proposition that you'd be citing it when granting a motion to dismiss on the grounds that the plaintiff didn't meet the standard, not for the proposition that the motion to dismiss should be denied because the plaintiff met the standard. That's not what Ducey stands for. There are cases enumerated within Ducey where, with deliberately ignoring evidence and multiple other factors, you could do a cogent analysis of a standard of actual malice, but Judge didn't do that. That's why I think this is hallucinated. Because it's not, first of all, it's wrong. Like, citing to Ducey there is actually wrong. If he had cited to Saint Amand for that proposition, it still would not be right, because and Connaughton, because those cases do have that concept in there, deliberately ignoring evidence that calls into question a published statement. But the test itself, even when you're looking at that, is way more manifold than just like the veracity or like ignoring evidence of the credibility of a source's statement. It's like all this stuff. You can publish a libelous statement by a source in the context of like an otherwise like legitimate exercise in fact finding. as an example. That's literally in Ducey. But the point here is that why it's not that he got the law wrong. It's not that he got just Ducey wrong. It's that he misattributed an incorrect interpretation of the progeny cited in Ducey, okay, and attributed it to Ducey for something that it doesn't even stand for in Ducey, because Ducey won. And Ducey was the defendant who got the case dismissed. Okay, do you see what I'm saying? That's why I think it's hallucinated. It's just wrong. It's not just wrong, it's such a rudimentary mistake about what the test is under Connaughton and St. Amand and McFarlane and Hunt. It's such a misunderstanding of the framework, even as helpfully laid out by the court in Ducey, okay? That just misinterpreting the standard and attributing it to Connaughton in that way would raise a red flag. Attributing it to Ducey, attributing that proposition to the Ducey decision is like F. The term paper gets an F from the student just for doing that. Just because I would be so pissed that you made me freaking read Ducey and then you misled me completely about what it stands for. Okay, and then I find out that although technically the words are in there, you actually misled me about the standard under Connaughton and St. Amand and Hunt and McFarlane. I'd be pissed. I'd be like, oh, the rulings are legitimate. I can't do this if the rulings are not legitimate. And that's not, it's just, I will finish the document, but that is making me so mad. Why did I even go to law school? What's the point? I wouldn't be allowed to get away with that. My torts professor would have been pissed if I tried to pull that shit. Maybe on a final if it was closed book and I was like, Professor, I was like summarizing from memory. And I got like, I know I only got like a third of the test and I attributed it to the wrong case and it didn't stand for what I was citing it to. But I had no notes, Professor. Come on, what do you want from me? Maybe I wouldn't be pissed in that situation. But when you're like, this can't happen. It can't happen. It's wrong. I've reviewed it 3 times now. It's wrong. It's incorrect as to Ducey, and it looks like it's hallucinated. I'm like 80% that this was hallucinated. Just not okay. I mean, this is a... If we're at this point, we just got to stop. We got to put a timeout on this. And we got to look. Okay? Somebody, like a competent judicial oversight authority has to review this. And if it's hallucinated, we got to put a timeout. Forget anyone's bias. Forget who golfs with whose husband. I don't care. Just, even if you do that, be good or be good at it. Timeout. If this is hallucinated, everything stops. Like, this can't keep going. Like, we stop. We pause. We don't sanction the judge. That's not how it works. We just pause. Because he's not up to it. I'm sorry. What do you want me to say? The first time this happened, and he got it blatantly wrong, we went through the analysis. I was not concerned about a hallucinated citation. I was he was just wrong. He was arguing, it was like a legal realist critique. He was just arguing towards a predetermined conclusion and making the case law bend to fit his reasoning. This is hallucinated, I'm almost positive. And it's really freaking me out. Because when lawyers hallucinate cases, it becomes like a big story. If Judge Gildea in this case, a very high-profile case, hallucinated a citation, dude, it's going to cause a crisis. First of all, it's going to cause chaos. Second of all, it's going to cause a crisis of confidence in the judiciary. And I'm not the final authority. I have read this over now twice or 3 times. I understand what I'm reading. Okay, I know what I'm looking at, and I'm telling you, it's not just that he's wrong, it's that the citation is hallucinated. I've read thousands, if not tens of thousands, of court motions and decisions. I know what I'm looking for. That's a hallucinated citation. Bar none, hands down. Aaron says, we fell in love in a hopeless place song again, please. We love you. Thank you for being you. You got it. I'm not turning down a request from Aaron at the end of the night. We only got 5 pages to go of this decision. God bless you, those of you, T.A. Sarah and the rest of you, who stuck through and learned about all that. That is dense material for a Friday night. If you care that much, God bless you. Like, truly. Like, most people want to get, like, the 40-minute summary. When we do this, it takes hours. You're shepherdizing. That's what you're actually doing, the case. You're actually looking at it as if like it were a living document and it like diving into it. That takes hours. And you all, like, you should feel proud of yourself. If you're sitting there thinking like, oh my God, he might be right, and you understand the implications and you followed that whole thing, God bless you. Truly. I'm astounded. Like, I would just sit here and do this on my own. You must understand. I look at your comments, but I can't, like, pay attention too much to what's because I'm, like, working. But, like, God bless you, truly. So we had a request for this song one more time by the wonderful Aaron, and you know you got it. Here it comes. Let's go. Aaron wants to hear it. Aaron gets it.
Diamonds in the light. Now we're standing side by side as your shadow crosses mine. What it takes to come alive. It's the way I'm feeling, I just can't deny. Let it go, let it go. We found love in a hopeless place. 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 Shine a light through an open door. Love and life I will defy. Turn away 'cause I need you more. Feel the heartbeat in my mind. It's the way I'm feeling, I just can't deny. Let it go, let it go. We found love in a hopeless place. 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 Yellow diamonds in the light. Now we're standing side by side as your shadow crosses mine. What it takes to come alive. It's the way I'm feeling, I just can't deny. Let it go, let it go. We found love in a hopeless place. 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 We found love in a hopeless place.
Good song. I got to do a little more research so we can have another song. All right, let's see. What else do we got? How about this? Let's go. I'm ready.
I chase the butterflies you give me, your venom gives me.
Do you know how hard it was to construct that test? That was incredibly difficult. Do you see now why? Like, do you know what? Do you see why he didn't do this? The test is like, if you actually were to analyze Aidan's communications with Natalie about 227, you have to look at this. Whether Aidan's investigation was grossly inadequate, that's Connaughton. Whether Aidan's story that he was working was or was not hot news, that's Saint Amant. Okay, gotta close that quote. 3. Whether the neutrality of Aidan's source was dubious, that's Hunt versus Liberty Lobby. 4. Whether the thoroughness and methodology of the publisher's presentation and the expertise of its authors. So, judge has to take into consideration that, Bose Court. But after those 4 things, judge then has to note, failure to investigate does not itself establish bad faith. That's St. Amant, 390 U.S. at 733. And finally, note under McFarland versus Sheridan Square Press from 96, actual malice may be inferred from an author or publisher's inability to corroborate a story only when, in attempting to corroborate, he encounters persuasive evidence that contradicts the allegation. McFarland v. Sheridan. Judge Gildea engaged with none of those 6 factors and entirely ignored New York Times v. Sullivan, and instead attributed the actual malice standard to simply a one-prong, quote, deliberately ignored evidence that called into question published statements standard, and also wrongly attributed that standard to Ducey. I mean, when you look at it that way and just rip it apart, it looks hallucinated. It really does. It looks lazy, hallucinated, incorrect, wrong, and dangerous. And I don't like when this happens, because I would never question the wisdom of a judge. Like, say judge went through this 6-factor test and was like, okay, I conclude thus. I'd be like, dude, I can't. Like, how am I supposed to pass, like, judgment on that? Like, he went through the factors, he has the record, he made his choice, like, appeal it. But if you don't get it right, then we have a serious problem. I mean, on a basic level, I can't analyze something that's just not right. Not right as a matter of fact, lazy, doesn't actually do the standard, just ignores it, like looks for a reason to just say, no, it's not actual, it was actual malice, you know? Just find some quote. Who cares? It's that bad. It really is that bad. I'm not under it. This is... Like, I know I want Attorney Little to look at it as well. I really do. But it really is. If she comes to this conclusion, if she didn't get a chance, that's fine. But I'm telling you I'm right on this. I'm telling you. I can just sense it in my towel bones. I mean, sense it, bro. I did the research. So, you know what? At this point, I do... think other lawyers, I'm not a lawyer, but I did go to law school. I do think other analysts will look at this, but I feel like very confident at this point because I did the work. Now that I actually, like, I did it, I wrote it out as I would like a final. I did the work. I'm right. I'm telling you I'm right. I'm telling you. Mark my words, I'm right. And the source is page 9 of 16. I gotta upload it and then share it. And if it were just like a small thing, I don't know what a small thing would be, but say it were just some like tangential issue that wasn't like the key to the entire case, I'd probably be like, you know, it's lazy, but it's not substantive. This is very substantive. I mean, dude, you can't get any more substantive than this. This is as substantive as it gets. I mean, it is the key. It's the key to the whole thing. Because even if it's just on these two, you can't analyze first of all, we have to talk about whether, like, Jen McCabe and the rest of them are public figures in actual malice. We didn't even get there. But, like, if they realizing how Judge is already thinking about actual malice, I mean, Aidan and Karen are in a lot of trouble. Because, first of all, he's wrong, and he's looking for reasons to screw him. That's the more dangerous part. And he's getting it very wrong. Where is my file? This is really bothering me. Where is my damn file? Getting all made? I just uploaded the damn thing. Why will you not let me use it? Like be all made? Oh, there it is. Right now I'm not as made. Alright, now I gotta go over here. Alright, then I gotta actually show, I gotta cite to the decision from Judge Gildea. Source, page 9 of 16. Alright, I think that's enough for the, like, lawyer crowd to look at this and determine if I'm right. Alright, it's done. That was hard. That was like a final. T.A. Sarah, you ready to take the test now? T.A. Sarah's like, oh my god, Professor doesn't mess around. Yeah, don't mess around. I don't mess around. Hi, Kim. It's so good to see you. Oh, kindergarten cop. I thought that was Kim. Hi, it's T.A. Sarah. I know, T.A. Sarah. Listen, it's going to be hard when we make the final. Alright, here's what I just wrote up. You can listen to it, then we'll finish the order. Then I'm going to bed.
Conversation. Excuse me, what? Did Judge Gildea use a hallucinated case citation in his order denying Karen Reed and Aidan TurtleBoy Kearney's motion to dismiss under 12b-6? Judge cites Levesque vs. Ducey, 560 F3D 82, 90, 1st CIR. 2009, for the proposition that W. Here Kearney deliberately ignore D. evidence that call ed. into question his published statements. Such allegations plausibly suggest recklessness amounting to actual malice. Source page 9 of 16. This was the crucial part of Judge Gildea's ruling issued on Friday, wherein Judge ruled that there is sufficient grounds for Brian Albert and Brian Higgins to move forward with the defamation claims against Aidan, assuming arguendo that they are public figures, because Aidan acted with actual malice when speaking to undercover agent Natalie the German. In the spring of 2023, while raising questions about Jen McCabe's infamous 2:27 a.m., 6:23 a.m., Hoss long to die in cold Google search, questions Aidan eventually resolved after further investigation, which Judge Gildea refused to consider in his order. Although that is an aside to the main point below. However, regarding the central point, the Ducey case does not stand for that proposition in any way, shape or form. Ducey is a case wherein the First Circuit affirmed a federal district court summary judgment, out of Maine, but applying the constitutional standard under NYT vs. Sullivan from 1972, in favor of the defendants in a defamation action SPECIFCLLY, because the actual malice standard is so high.
I spelled specifically wrong.
Quoting the court in Ducey, the actual malice standard, adopted to ensure a vibrant media check on official action, requires more of Levesque to survive summary judgment. Certainly, as we noted above, it exacts a high price from the victims of defamatory falsehood. Plainly, many deserving plaintiffs, including some intentionally subjected to injury, will be unable to surmount the barrier of the New York Times test. Gertz, 418 U.S. at 342. This action reminds us that in a court of law, sympathy does not always to the victor go. We find that Levesque cannot survive the defendant's motion for summary judgment. Source. The actual malice standard from Ducey is, actually, thus. A public official advancing a defamation claim must show that the challenged statement was made with a high degree of awareness of probable falsity. Bose Corp. 692 F2D at 195, internal quotations and citation omitted. In other words, the defendant must act either with actual knowledge of the falsity or with reckless disregard for the truth. New York Times Company, 376 US at 279-80. Actual malice then is measured neither by reasonably prudent conduct, Hart Hanks Comken, Inc. vs. Norton, 491 US 657, 688, 1989, nor an industry's professional standards, Howard, 294 F3D at 250. Saint Amand vs. Thompson, 390 US 727, 731, 1968. Levesque does not suggest that the defendants actually knew the Plagman article provided false information. Thus, he must show sufficient evidence to permit the conclusion that the defendant, S., in fact entertained serious doubts as to the truth of the Plagman article and the statements it attributed to Levesque. Id. And, also, recklessness amounting to actual malice may be found where a publisher fabricates an account, makes inherently improbable allegations, relies on a source where there is an obvious reason to doubt its veracity, or deliberately ignores evidence that calls into question his published statements. Norton, 491 US at 684-85, Saint Amand, 390 US at 732. See Hunt vs. Liberty Lobby, 720 F2D 630's preparation and the expertise of its authors, but see Saint Amand. 390 US at 733, failure to investigate does not in itself establish bad faith. McFarlane vs. Sheridan Square Press, Inc., 91 F3D 1501, 1511, DCCIR. 1996. Cetual malice may be inferred from an author's or publisher's inability to corroborate a story only when, in attempting to corroborate, he encounters persuasive evidence that contradicts the allegation. Further, Ducey stands for this reasoning. It is true that a more deliberate consideration of the Plagman article should have caused reasonable skepticism about the source and that the 8 defendants were careless in relying on it, but this is an indication of negligence, not actual malice, and Superintendent Levesque faces the heavy burden of providing evidence that the defendants recognized the carelessness with which they were proceeding. See Saint Amand, 390 US at 731, R. Reckless conduct is not measured by whether a reasonably prudent man would have published, or would have investigated before publishing. Thus, the citation Judge Gildea referred on actually comes from this section of Ducey. In turn, I am almost certain that citation to Ducey is hallucinated as the actual cases in question are Hart Hanks communes versus Norton, 491 US 657, 9, and, further, that the test from those cases is far more complex than simply whether Kearney deliberately ignore d. evidence that call ed. into question his published statements, which, by the way, is not even the standard from Ducey, but instead a multi-pronged test that involves 1. Whether the investigation was grossly inadequate. 2. Whether the story was, or was not, hot news. 3. Whether the neutrality of the source was dubious. 4. The thoroughness and methodology of a publisher's preparation and the expertise of its authors. 5. But, importantly, note that failure to investigate does not in itself establish bad faith. 6. And, finally, note that actual malice may be inferred from an author's or publisher's inability to corroborate a story only when, in attempting to corroborate, he encounters persuasive evidence that contradicts the allegation. Judge Gildea engaged with none of those 6 factors, and entirely ignored New York Times versus Sullivan, and, instead, attributed the actual malice standard to simply a one-prong, deliberately ignore d. evidence that call ed. into question published statements standard, and, also, wrongly attributed that standard to Ducey. QED. Bonus Friday Night Towel income.
Done. Got him. We'll continue with the order, but I'm telling you I got him on that. I'm telling you. Barring some... Listen, you know what? I'm actually willing to say with 99% certainty I got him. There is no way I misread any of that. Because even if I misread, like, the way that some of the cases, Connaughton, St. Amand's, Bose, whatever, were interpolated through Ducey, like, he didn't even engage with the standard from those cases. So, no. Nope. Done. Got him. I'm telling you. Barring some very odd, like, very odd thing that I missed, which I didn't, because I read every word of Ducey with you. We got him. That is a hallucinated citation. I want a lawyer's opinion on this, but I'm pretty sure we got him. Oh, wait a minute. We hit the goal already. Ladies and gentlemen, I forgot to restart. So the goal already ended. We can say we hit the goal. I will absolutely show you goats, but we got to finish the actual order. It gets worse, by the way, okay? But the hallucinated citation, I mean, if it's confirmed, that's it. That's game over. Okay? That's just game over. There's no... It just doesn't go beyond that. He can't have been wrong on that. It's like the core, because a lot of this is going to be about the actual malice standard. So to be wrong about that from the jump, in the most like intense way, is just devastating to the ruling. So, all right, let's continue. We're almost done.
Samuelson versus Bloomberg LP, 903, F. 3rd 1924. Is 3 contrary to Kearney's argument that the FAC states that Kearney published 545 parts of the Canton cover-up. Series CFAC at paragraph 46 does not mean that every article is relied upon in framing the complaint. 9. Circa 2018. At motion to dismiss stage, all that is required are facts that nudge the actual malice claim across the line from conceivable to plausible.
Okay, that's fine. What's the citation there? Because of the court's conclusion as to the defamation claim, Kearney's arguments that all of Brian Higgett's claims, because they derive from and depend on the defamation claim, necessarily fail. Yeah, I don't think that's right. But let me just say, okay, so say this is right, okay? This is probably right. At the motion to dismiss stage, all that's required are facts that nudge the actual malice claim from across the line from conceivable to plausible. Fine. You still got to engage with the actual malice standard. And that's just not what it is. Just entertaining serious doubts is not enough. They're not. You can say that he entertained serious doubts, but if the crux of it is that deliberately ignoring evidence called into question his published statements is your argument for why that's reckless, and you cite Ducey, you're wrong. I mean, maybe you can get to the point where part of the analysis of the test, not from Ducey, but from St. Amans and the other cases, Hunt, etc., is that there is an element of whether the author entertained serious doubts. That's part of it. That might be part of it, but that is not all of it. And not only is it not all of it, it's certainly in a like 6-factor, very complex actual malice standard when you actually look at all the things for actual malice when a publisher's making the statement to apply. It's like, how can it nudge it? Maybe that's right. I don't doubt that the standard is at the motion to dismiss stage that it just needs to nudge it. But even still, you got to engage with the actual malice analysis for it to nudge it. Maybe like you don't have to. Maybe you take all those 6 factors or whatever it is, and you say, okay, so like he did 3 of them, didn't do the other 3, and you weigh them out. And then maybe that nudges it where it, at motion to the summary judgment, it wouldn't make it at all. Fine, that's something I can engage with, but he didn't do that at all. I promise you he didn't. He narrowed in on one factor, misapplied it to the Ducey case when it doesn't apply. That's just wrong. And then took that one factor and made it the basis for the entire reasoning for why Aidan acted with actual malice, and therefore the motion to dismiss should be denied at the 12B6 stage. To actually be legitimate, what this ruling would need to engage with is all of those factors, because there's some of them that tip in Aidan's favor, like you don't have to do a complete investigation, etc. All those factors we went through. If you went through all of them and were like, 2 tip in Aidan's favor, 4 tip in the plaintiff's favor, so therefore it nudges it. Okay, dude, I don't got a I'd be sitting here like, I don't really agree. But that's sound. That's what you have to do. What was done here is just not right. It's so wrong. I don't know what happened between this statement, okay, right here. Like, it started from the wrong place and the wrong case. And it just, like, applied that, like, very affirmatively as the lone standard to justify, because the first part is more just about, like, why judges rejecting looking at further articles published by Aidan for Aidan to argue that he did do further investigation, and then that initial question about the Google search wasn't a big deal because he eventually, like, understood the context. Either way, so therefore he still believed Karen more after he understood about the 227 search from, like, the evidentiary perspective. That's not really the point, though. The point is that after that, Judge then goes back to this sort of argument, and he's like, no, listen, here we have one big piece of evidence that Kearney entertained serious doubts as to the truth of his statements from his source, and that's actual malice. No, it's not. No, it is not. If it were just me, like, Googling this random case and being like, well, you know, Levesque v. Ducey, and then the progeny says, no, he cited to it. He cited to it. And that is just not the standard. The standard is whether the investigation was grossly inadequate, whether the story was or was not hot news, whether the neutrality of the source was dubious, the thoroughness and methodology of the publisher's preparation, and the expertise of its authors. But importantly, note that failure to investigate does not in and of itself establish bad faith. And finally, actual malice may be inferred from an author or publisher's inability to corroborate a story only when, in attempting to corroborate, he encounters persuasive evidence that contradicts the allegation. Can't be persuasive if after he looked into it more, it was not a concern to him regarding Karen's story. Point one. Point two. Say that you do want to take this standard down here, which is the whole point. It's at the motion to dismiss stage, all you need is facts that nudge the actual malice claim across the line from conceivable to plausible. Fine. But you still have to do it in the context of this test. And even if it is this test, maybe people would word it differently. You still have to look at all this and then say, okay, based on all this, what I see in the First Amendment complaint nudges it over the plausibility stage. But he didn't do that. He narrowed in literally on, like, one subset, okay? Literally one subset of what is, like, technically, like, the Connaughton standard, like whether the investigation was grossly inadequate. That's a factor in there, like deliberately ignoring evidence, okay? And he ignored everything else. Completely ignored it. He cites to it later on. Some of these cases, Bose and whatnot, come up. But that was his whole analysis. All he basically did was misattribute one part of Connaughton to Ducey and then say that's the actual malice standard. Do you realize how bad that is? I mean, seriously. I can't get over this. Like, I just can't. To actually see, like, some of the ruling have legitimacy, like, that's probably fine. But then to have it all based on a completely hallucinated citation. All right, now we'll go to by the way, it gets worse from here. I'm not going to tear the rest of this apart because the logic tears it apart, but watch where it goes from here.
Citation omitted. B. Chapter 93. A claim as to all plaintiffs. General laws. Chapter 93. A. Section 9 provides a private cause of action for individuals who suffer an injury because of unfair or deceptive acts or practices committed by those engaged in trade or commerce. Cassavant versus Norwegian Cruise Line, Limited, 76 Massachusetts Appeals Court, 73-76, 2009, citing. Hirschenau versus Enterprise Rent-A-Car Company of Boston, Incorporated, 445 Massachusetts, 790, 796, 2006, to state a claim under Section 9. A plaintiff must allege facts sufficient to establish 4 elements. First, that the defendant has committed an unfair or deceptive act or practice. Second, that the unfair or deceptive act or practice occurred in the conduct of any trade or commerce. Third, that the plaintiff suffered an injury. And fourth, that the defendant's unfair or deceptive conduct was the cause of the injury. Rafferty versus Merck and Company, 479, Massachusetts 141, 161, 2018, citing GL Chapter 93A, Section 2. Under GL Chapter 93, A Section 2, unfair or deceptive acts or practices are declared unlawful only where they occur in the conduct of any trade or commerce. Kearney argues the plaintiff's Chapter 93 claim fails because they have not alleged any facts to establish that they and Kearney were engaged in trade or commerce with each other and therefore acting in the business context. However, the plain language of the statute does not require that a plaintiff have a business or transactional relationship with the defendant. Section 9 provides a cause of action to Milkiwa, a J9 person who has been injured by another person's use or employment of any method, act or practice declared to be unlawful by Section 2. Emphasis added. Section 2 prescribes unfair or deceptive acts or practices in the conduct of any trade or 4. Because of the court's conclusion as to the defamation claim, Kearney's argument that all of Brian Albert's and Higgins's other claims should be dismissed because they derive from and depend on the defamation claim necessarily fails. 10. Commerce. There is no language in the statute itself that requires a transactional relationship between plaintiff and defendant for a claim under Section 9. See Rafferty, 479 Massachusetts, at 162, Note 7. Unlike claims under Section 9, claims under Section 11 require not only that the defendant's conduct occur in trade or commerce, but also that there be a commercial transaction between the parties. Nor is there any requirement of contractual privity between the plaintiff and defendant. C. Melier versus ATF, Davidson Company, 407, Massachusetts 185, 191, 1990. See also Cardi versus F. Hoffman Law. Roche, Limited, 436, Massachusetts 53, 60, 2002. Privity not required because it's a plain and unambiguous language of Chapter 93 allows any person who has been injured by trade or commerce to bring a cause of action. The facts alleged here present somewhat of a novel issue where the plaintiffs are not traditional consumers of the defendant's product, but allege a connection to the alleged unfair or deceptive act, and that they have suffered harm by the defendant's conduct in trade or commerce. Specifically, the FAC alleges that Kearney has sold merchandise with the plaintiff's names and likeness and sold subscriptions to his content, which consists of defamatory statements about the plaintiffs, while the parties make general arguments about the trade or commerce requirement of Chapter 93A. Neither cite Massachusetts appellate cases that shed light on this issue. Given the novelty of the issue before the court, whether Section 9 affords a remedy to the plaintiffs is an issue best not determined on a motion to dismiss. See Baker versus Wilmer Cutler, Pickering Hale and Dorr, LLP 91 Mass. App, CT, 835, 849 to 850, 2017, citing Ritchie versus Department of State Police, 60. 5. The federal cases interpreting GL, Chapter 93A, Section 9, and Massachusetts cases referring to Section 11, cited by
H.A.M, it's so good to see you, my friend. Yes, I hope all is well and things have been mostly peaceful. I've been keeping an eye on Herbal. I saw that strike last night. God bless you and your family. I hope they are all well. We have been covering a number of criminal and civil cases in Massachusetts, so feel free to pop in anytime. And what's really interesting is you may have heard me talking about some of that state police corruption that I was covering while the war was going on. Turns out they were covering up a potential child trafficking ring connected to cops. Oh yeah, damn right. And it may be connected to you-know-who, Epstein himself. My little old state of Massachusetts, indeed. I hope your family has been safe. God bless them. I'm so glad to hear your dad made it on his flight that he was on. I remember that from all the way back then. God bless you, my dear friend, and so good to see you. Warms my heart to see you pop in. I hope you're well.
Kearney, do not compel this court to conclude a transactional or business relationship is required under Section 9. Kearney also cites a BOA 1999 Superior Court case to support his argument. Cook versus W.H.D.H. TV in Committee 1999. WL 1327222 at *4 Mass Super 1999. Bone J, which similarly has no binding precedential value. While the court acknowledges that Massachusetts appellate cases generally refer to plaintiffs in Section 9 as consumers, Kearney has cited no such cases. Foreclosing a Section 9 claim because the plaintiffs did not have a business, commercial, or transaction relationship with the defendants. Illinois, Massachusetts, Appeals Court 655, 663, Note 14, 2004, faced with fact-intensive and novel theory of recovery. Better practice is to deny motion to dismiss and allow parties to develop facts through discovery. 2. Reed's motion to dismiss. The plaintiffs assert claims against Reed for defamation, intentional and negligent. Infliction of emotional distress, for aiding and abetting in Kearney's defamation and infliction of emotional distress, and for civil conspiracy. Reed moves for dismissal of all claims against her. The court is not persuaded by her arguments. A. Defamation. As noted, to state a defamation claim, a plaintiff must allege that the defendant published a false statement about the plaintiff that the statement could damage the plaintiff's reputation in the community, and that the statement caused economic loss, or is actionable without economic loss. Schultz, 473 Massachusetts, at 249. Statements that charge the plaintiff with a crime are actionable without proof of economic loss. Ravnikar, 438 Massachusetts, at 630. Red asserts two arguments for dismissal of the plaintiff's defamation claim. Neither is persuasive. First, Reed contends that the defamation claim should be dismissed because the FAC fails to comply with Massachusetts Rule of Civil Procedure 8A. Under Massachusetts Rule of Civil Procedure 8A.1, a complaint must include a short and plain statement of the claim showing that the pleader is entitled to relief. The FAC states several allegedly defamatory statements by Red. See, for example, FAC at paragraphs 93 to 97. Thus, it sufficiently complies with Rule 8A in that it affords fair notice to the defendant of the basis and nature of the action against her. See Colorio v. Marks, 72 Massachusetts Appeals Court, 382, 386, 2008. Second, Reed contends that her allegedly defamatory statements are not actionable because they are untimely, barred by the litigation privilege, or otherwise fail to state one of the elements of a defamation claim. Her argument, however, fails to acknowledge many statements. 12. In the FAC, for instance, the FAC alleges that in April and June 2024, Red falsely told a documentary filmmaker that McCabe was a first-degree murderer, that the plaintiffs are murderers, that Brian Higgins, Brian Albert, and Colin Albert had a motive to kill O'Keefe, and that Brian Albert and Colin Albert would have enjoyed roughing John up. FAC at paragraphs 93 to 97. Reed makes no argument that such statements are untimely, protected by any privilege or otherwise cannot be considered defamatory. Thus, even if some of Red's statements in the FAC are not actionable as defamation, other statements in the FAC plausibly allege a defamation claim. Therefore, dismissal is unwarranted.
Can you believe that? The only reason Karen lost her motion is because of the stuff she said to the documentary filmmaker who she trusted to be embedded with her team. Is this Air Supply song from the 80s? I don't know. Grant, thank you for all you do. God bless you, says Aaron. God bless you, Aaron. You're wonderful. Are you telling me Karen would have been out of this lawsuit but for what she said to Terry Maurer? Or the documentary filmmaker? Who was embedded with her team, who she trusted? User says, Grant, I bet you can tune the accent in different countries in New England. They were all different, I learned as a kid. Oh yeah, so this one that I have, it's expensive, but it's worth it. It has like cool tones. I have to generate them though ahead of time. It takes it's this whole process, but they're worth it. It saves. So my throat really hurts if I try to read, as I'm sure any legal analyst, even though I'm not a lawyer, but I do analyze court documents, will tell you. Trying to read thousands of pages will break your voice down. So I'm trying to find the best voices for these documents. This one is more because, it's Judge Gildea, but we have some really good ones that I found recently, and they're very helpful as accessibility tools. So, and I've heard they're catching on for case reads, so good. I'm all about it.
B. Intentional and negligent infliction of emotional distress. To state an intentional infliction of emotional distress claim, the plaintiff is required to
User, that's an excellent skill to have, to be able to identify someone from where they're from based on the intonation in their accents. Incredibly valuable skill to have.
show 1. That the defendant intended, knew, or should have known that her conduct would cause emotional distress. 2. That the conduct was extreme and outrageous. 3. That the conduct caused emotional distress. And 4. That the emotional distress was severe. Pole versus McMahon, 468 Massachusetts, 379, 385, 2014. To state a claim for negligent infliction of emotional distress, plaintiff must allege 1. Negligence, 2. Emotional distress, 3. Causation, 4. Physical harm manifested by objective symptomatology, and 5. That a reasonable person would have suffered emotional distress under the circumstances of the case.
Also, I thought I saw Triple E Bob in chat earlier. I might have missed him. How you doing, Triple E Bob? You're a towel.
Citation omitted. Rodriguez versus Cambridge Housing Authority, 443 Massachusetts, 697, 701, 2005. Reed's motion to dismiss these claims fails for several reasons. Reed contends that the plaintiff's emotional distress claims are based on her allegedly defamatory statements and therefore cannot satisfy the extreme and outrageous conduct requirement of an intentional infliction of emotional distress claim as a matter of law. However, false and defamatory statements may, under certain circumstances, be sufficient to constitute 13. Extreme and outrageous conduct. Registered trademark C-Tech Plus, Inkir versus Ansel, 59 Mass. App. Seat 12, 26, 2003. Moreover, this argument fails because the plaintiff's intentional infliction of distress claim goes beyond the allegations of defamation. See FAC at paragraph 175. Reed does not specifically address, for example, allegations that she orchestrated a coordinated campaign to falsely accuse the plaintiffs of murder, or that she knowingly destroyed the reputations and lives of innocent people to deflect attention away from her own culpability in O'Keefe's death. Or the many factual allegations within the FAC explaining how she did so. ID. Such allegations may reasonably be considered extreme and outrageous. See Boyle versus Wenck, 378 Massachusetts, 592, 597, 1979. If reasonable people could differ on whether the conduct is extreme and outrageous, then that issue is for the jury. Compare Sokol versus Best, 25 Massachusetts Law Reporter, 600, 606. Massachusetts Superior 2009. Hogan, J. Allegations that defendants threatened to take the plaintiff to court for a crime they knew he did not commit sufficiently alleged extreme and outrageous conduct. As to the negligent infliction of emotional distress claim, Reed's argument fails for a similar reason. She selects specific allegations in the FAC and argues why her statement's in. Those paragraphs are not actionable, but she does not address her alleged creation of the campaign of lies on which the claim is based. See FAC at paragraph 196. Accordingly, Reed's motion fails to show that the emotional distress claims against her should be dismissed. C. Aiding and abetting and civil conspiracy claims. To state a claim that Reed aided and abetted a tort, the plaintiffs must show 1. That Kearney committed the relevant tort. 2. That Red knew he was committing the tort. And 3. That 5. Reed relies on Ayadurai versus Floor 64, Inc., 270F. Supi. 3rd, 343. 370. D. Mass, 2017. A decision from the Federal District Court is not binding on this court, and unlike that case, the plaintiffs here do not seek to hold Reed liable for mere insults, indignities, threats, annoyances, petty oppressions, or other trivialities.
It is binding.
Citation omitted.
It is binding if it's a constitutional question, though.
7. D. 14. Reed actively participated in or substantially assisted in his commission of the tort. See Go Best. Assets Lid versus Citizens Bank of Massachusetts, 463 Mass. 50, 64, 2012. A claim for civil conspiracy based on a concerted action, as alleged here, requires the plaintiffs show a common design or an agreement, although not necessarily express, between two or more persons to do a wrongful act and, second, proof of some tortious act in furtherance of the agreement. Aina, Cas, Sur, Co, V, P and B Autobody, 43F3D, 1546, 1564, First Surrey 1994. See Kirker versus Hill, 44, Massachusetts Appeals Court, 184, 188, 1998. In concerted action civil conspiracy, liability is imposed on one individual for the tort of another. Reed argues that the aiding and abetting and civil conspiracy claims should be dismissed, because as argued in Kearney's motion to dismiss, the tort counts against him fail to state a claim. As explained above, this argument fails. Reed also argues that the claims fail because the FAC does not allege that she substantially assisted Kearney by providing him information to lie about the plaintiffs. However, Reed, once again, fails to acknowledge allegations in the FAC that are detrimental to her. Argument. The FAC alleges that Red found and enlisted Kearney to publicize and spread her lies about the plaintiffs, and he agreed on a scheme to do so, that Kearney made false statements about the plaintiff's culpability in O'Keefe's death at the direction of Red, that Red provided selective and distorted information to Kearney that she purportedly obtained from a federal law enforcement authorities that was not public and she was not authorized to share. That Reed provided false statements about grand jury testimony to Kearney that she provided. Kearney with personal identifying information about the plaintiffs, which he published to his audience, and that she encouraged his spreading of defamatory statements. F. A.C. at paragraphs 22, 25, 29, 37 to 38, 49, 74. Such allegations are sufficient to plausibly allege that Reed's actions were a 15. Substantial factor in Kearney's ability to defame and inflict emotional distress upon the plaintiffs. See Massachusetts Port Authority versus Truro Incorporated, 487 Massachusetts, 235, 244, 2021. Substantial assistance may be established by demonstrating that the alleged abettors' actions were a substantial factor in the tortfeasor's ability to perpetrate the tort. See also Peyton versus Abbott Labs, 512 F. Suppu, 1031, 1035, D. Mass. 1981, citing a comment on Clause B. Restatement Section 876, to determine substantial assistance, court considers, among other things, the nature of the act encouraged and the amount of assistance given by the defendant. Accordingly, dismissal is also unwarranted as to the aiding and abetting in civil conspiracy. Claims. Order. For the foregoing reasons, Defendant Aidan Kearney's partial motion to dismiss pursuant to Massachusetts Rule of Civil Procedure 12b-6 is denied. Defendant Karen Reed's motion to dismiss pursuant to Massachusetts Rules of Civil Procedure 12b-6 is also denied. August 14th, 2026. Mark C. Gildea, Justice of the Superior Court, 16.
Good job, everyone. We made it. Listen, I'm not an expert in 93A, so I can't do that part as much. The IED, I know Boyle v. Wank, and then I know Howard Johnson Co., which is like one of the original cases on IED and NEID and not needing physical harm to claim NEID or IED. Had to do with like some woman getting harassed by a debt collector, if I recall, way back in the day. But Boyle v. Wank's another case I've heard of. But 93A, way outside of my... I'm not a lawyer, obviously. I've said that multiple times. I did go to law school. But 93A, I just don't do that stuff. It's just not in my wheelhouse. Other lawyers or law students or analysts might have been able to do that part. I can learn about it, but I'm not. I'll just tell you where I'm not an expert. That's just not my wheelhouse. 93A. I know about like 30A, like petitions for writ of certiorari to review an administrative action, but I don't know anything about 93A. The NEID and IED stuff. So the problem there and the conspiracy stuff, it all really hinges on the defamation stuff, which in turn hinges on Aidan's actual malice, which Judge Gildea did not engage with. So like Karen's ability to win this case and Aidan's ability to win this case really come down to whether on the defamation stuff, and a lot of the Higgins and Albert claims are derivative. The Brian Higgins and Brian Albert claims are derivative of the defamation claims. And then, frankly, I think there's a good argument that Jen McCabe and Matt McCabe and Higgins Albert and Nicole Albert, if those are the parties, are public figures. Here's the problem. A public official and a public figure under NYT v. Sullivan are the same thing. Whether you're a cop or like a major public figure because you're a witness in a high profile case and like you think right away you're going to be like portrayed by Salma Hayek or whoever, Sandra Bullock, like you're a public figure. Like that's my opinion. It's the same thing as being like a cop in terms of the actual malice standard. So really all of them, like an appropriate analysis here is actually actual malice for all of them. But you got to do the determination, which frankly, I guess is going to happen at summary judgment, about what, or maybe, I suppose, it should have happened now, whether they are public figures. It's like a threshold issue. If all the plaintiffs in this case are public figures, and then all the defamation claims are subject to the actual malice analysis, that's how I have to say it, then, yeah, I mean, that changes the whole dynamic, because the whole ruling hinges, really, not the 93A stuff, but the whole ruling on the NEID, the IED, the conspiracy, the defamation, hinges on whether or not Aidan had actual malice. And actual malice is not what Judge said it was. Actual malice is a standard, literally, judges circumventing what is like constitutionally enumerated precedent through NYT v. US. NYT v. Sullivan. NYT v. US is the Pentagon Papers case from the same period of time. Very easy to get those two mixed up. But my point remains the same. Like, the reason we have this is like a core constitutional issue. The reason we have the actual malice standard, you heard the court say it in Ducey, is that it's supposed to inhibit public figures from stifling criticism and public officials. Like, that's like the First Amendment doesn't only mean something in the criminal or like what state action context. It matters in the context of NYTV US because it's central to the elevated actual malice standard. It's actually like a vanguard against tyranny. That's the whole point. And you can't do what Judge did here. Dude, why do we have NYTV US with this kind of rulings going to come out? Though it's like the NYTV US, the actual malice standard is not as robust as the First Amendment, but it is as sacrosanct for a reason. Like, do you know what would happen? Now, this is a unique case, but do you know what would happen if public figures could just sue people for what they like say about them, like willy-nilly? It would be really bad. It would. That's why the court cut that off with NYTV US. Now, if Judge Gildea engaged with that and like determined there was actual malice under the relevant standard and progeny, I'd be like, yeah, I don't agree with it, but like, that's why we have appellate courts. But he didn't do that. He circumvented the key, like, foundational precedent of actual malice law and all its progeny, and just disregarded why we have that standard to begin with. This is a very special form of law, actual malice, and public figures and limited purpose public figures and etc. That's a very special area of law, and the reason why nobody ever challenges it is, barring a ruling like this, you would never see a court be like even come close to like questioning SCOTUS's judgment in NYTV US about like the importance of an elevated actual malice standard. It's like a very like foundational principle of like the public forum, this standard from NYTV US. Well, we can read it. We're not going to read it now. It's a long case. It's very long. Excuse me, NYTV Sullivan. It's a very long case about an article published in the New York Times. They end up winning. Okay? But the point remains the same. We'll revisit it on a night where I'm not exhausted. The point remains the same. Maybe I'll do like a whole lecture about NYTV Sullivan, because like I want to read it again, and then I'll lecture you about it. But the point, the takeaway from NYTV Sullivan is that when you, as you learned today, when you are a public figure, whether you become one on your own accord, whether you become one involuntarily, whether you're a limited purpose public figure, when you're a public figure and you sue for defamation, the standard is actual malice. And when the standard is actual malice and you're talking about a publisher, it's very high. It even allows mistakes. It allows for people to publish like a libelous statement by a source, as you learned today, as long as you do otherwise like due diligence in the reporting. Like as long as you're trying to get to the truth, basically, and you're within the actual malice standard of a public figure, public official, limited purpose public figure, involuntary public figure. Like the most important thing is not like, did you get it wrong? Okay, you can get it wrong, but it's like, were you trying to get to the truth? And that's a very complex analysis that has all this wiggle room, not gratuitously. It's not like we just have this random case law about actual malice. It's there to protect the public forum. And therefore, it has all these like built-in protections where if you do certain things, even that are like very like inflammatory and like, hey, like look over here, like pay attention to me, I want you to watch what I'm doing, like give me views. Even if, as you learned about morning shows and the genre of morning shows from the court, the appellate court in Ducey, even if you do that, that can sometimes be okay. That's not a problem. Even if you cause like serious injury to people, that's, the court said, like that happens sometimes. It's a price we have to pay for like the public forum. Like this is what we do. We have robust debate. People are wrong. People correct things. People learn as they're covering something. We never want to discourage that. That's the whole concept of NYT v. Sullivan. That's the core, the nexus, the constitutional nexus. Everything that flows out of NYT v. US, v. Sullivan, like the cases we looked at today that were cited in Ducey, I have them all here. This one, they'll load up slowly, but like Connaughton was one of them. And then what was the other one? The E. Howard Hunt case versus Liberty Lobby. And then Nerman was another one. All these cases flow from a similar place, which is New York Times v. Sullivan and the elevated actual malice standard. And then the way they like break down the actual malice standard, it's fact specific, but it builds a test. Okay, they give us a test. Like it's very spread out across circuits, but it's a test. And you can't just ignore the test when the central issue in this case, outside of the 93A claims, but the central issue upon which almost everything hinges is like whether or not, one, all these plaintiffs are public officials, public figures, etc. And then therefore whether NYT v. Sullivan applies. And then once we're in there looking at the fact-specific inquiry about the only thing Judge Gildea said was evidence of specifically Aidan questioning Karen's narrative. If we look at the totality of the circumstances related to the 2:27 a.m. search and when Aidan first learned about it and questioned Natalie about whether it made him lose confidence in Karen's narrative, but then Aidan learned more over the coming weeks and then came to see how everything actually aligned with what he was thinking Karen was telling him, okay? If you look at all of that, and then you apply the 6-factor analysis that I think comes out of those 3 cases we just talked about as the court explicates in Ducey, then what you get is a very different conclusion than what Judge Gildea came to here. And second of all, it offends me on a personal level to reduce the actual malice standard to the way Judge Gildea reduced it. What did he reduce it to? Like, knowingly ignoring, deliberately ignored evidence that called into question his public statements. To reduce a case I consider one of the most important in American history, New York Times Co. v. Sullivan, to deliberately ignoring evidence that called into question public statements is absurd. It's offensive. It's so dangerous as to be tyrannical. No other press outlet. If this happened to the Associated Press, it would be a freaking scandal. It would be a scandal. And the press has got to realize, like, it's a bigger issue than just Aidan here. We're talking, like, if they set this standard First of all, it would overturn New York Times v. Sullivan. That's not happening. Second of all, like, it would fundamentally change public discourse in this country in a bad way if that were the standard. It's not, thank God. He got this so wrong. Like, this is a very important area of law. People who do this area of law, like, care about it, like, with their whole heart. When you are talking about, it sounds like it's a 1972 case. It's not. It's like the modern First Amendment for reporters, basically. This is a very important area of law, and he has no idea what he's talking about. Not only does Judge Gildea not know what he's talking about, he, I think, hallucinated a citation that is the crux of the entire order. Not the entire order in the sense of what's the word? Not the entire order in the sense of the 93A claim, but the entire order basically comes down to how Judge Gildea just ruled on the actual malice standard, and he turned it into this notion that if you deliberately ignore evidence that call into question your published statements, therefore you've acted with actual malice because it's reckless disregard for the truth. No, that's not right. That's part of the Connaughton standard as to whether the investigation was adequate. But to reduce that case, that seminal case on constitutional law from the Supreme Court to nothing but, oh, if you deliberately ignore evidence, and by the way, even if you like figure out why that evidence wasn't actually like a condemnation of your source's integrity later on, if you just like, if you get something that makes you like question your source and then go forward, even if you later learn, that what your initial skepticism was unfounded, that's actual malice. No, it's not. No, it's not. Absolutely not. I mean, setting aside the fact-specific inquiry in this case, which I'm not going to apply the facts of this case to the test, that is not the test. And the test exists for a reason. This is not one of those, like, convoluted issues, like, related to, like, administrative reviews of, like a permitting ordinance, which are important, but it's not really a constitutional question. Like the statutory legitimacy of business permitting ordinances. I freaking, like, Judge Gildea will hear me on this one. I love business permitting ordinances. Crap. You mess with 94G 31AI, you know who you're gonna get? Like at your public meeting? Me. Yelling about it. Alright? Because I love business permitting ordinances. Mixed use zoning. Oh God, it makes my heart sing. You don't understand. Business overlay districts. You're telling me that I can take a map of a city, look at it, and determine which types of businesses are most appropriate to operate in which area, and that I can zone them? And that I can, like, make sure that nobody plays loose and fast because they know some city councilors, so they want their plot of land zoned only for a specific business, and then they raise the rent because only 3 plots of land in the whole city can have that type of business? Oh, I love that type of stuff. It's like playing chess. It's great. They make my heart sing. All right? But in terms of, like, constitutional prerogatives, like, I understand. I care a lot about business permitting ordinances. They're not really, like, constitutional, like, weighty constitutional issues. They're really cool, but they're not weighty constitutional issues. They never will be. They might sometimes implicate, like, the takings clause, like, eminent domain, but it's very rarely a constitutional issue. This is a constitutional issue. Again, this is, like, when people figure this out, I'm going to go to bed soon, but I want to hear what Attorney Little has to say about this in the morning, because I'm telling you, I think this is a big deal. I think it's a big deal that Judge Gildea has reduced the actual malice standard to a one-prong test and then narrowed in on one statement out of context in the full timeline that Aidan made to Natalie, and then said that that's the reason why Aidan acted with actual malice. If that's true, all of us in the news business should be concerned. All of us. Because any source can tell you something at one point that makes you be like, wait a minute, bro. Like, you said, like, the business was at, like, 400, like, West Main Street. I went there, like, that, there's no building there. And the source is like, oh, dude, I'm so sorry. Like, it's 400 East Main Street. I don't know if, like, I told you West, or if you wrote it, or if I texted you, or if it auto-corrected. And then you go to 400 East Main Street, and you're like, but in that moment, you're like, did this guy or a person, like, make this shit up? Like, why'd they send me to a, like, fake building? Like, were they testing me? So you're, like, already on guard. And then you're like, all right, I'm going to drive over to 400, like, East, like, Main Street. And let's just see. You go over there, and then you breathe this big sigh of relief. You're like, oh, shit. Like, there's the building. And so you call the person, and you're like, dude, I'm here. You were right. It was 400 East Main. Like, I questioned your credibility. I want to be direct with you. I thought you had lied. But you're right. Like, we just miscommunicated on that one letter. In that initial moment, did I, like, immediately think the source was lying in this hypothetical? Yeah. Dude, as a reporter, I think you just lied to me. I think you thought I wouldn't go down there and check to see whether there was a building. And you lied. Now, in this case, I'm not going to call you a liar. I'm going to be like, can you explain? Because that's the reasonable thing to do. Like, I'm having serious doubts. I'm in the middle of a city. I don't know. You sent me here. I told you I was going to verify it, and now there's no building. But then, like I said, you could get something as simple as, oh, you just heard me wrong. And then you go to the right address, and the story keeps going from there. How am I supposed to, like, do that if every time a source tells me something I have to confirm, that immediately is evidence of bad faith? Are you kidding me? That's what I'm supposed to do. I'm supposed to, like, be very hypercritical of the source. They can earn trust over time if they're right about a lot of things over and over and over again. But my job is to say, like, okay, you're telling me this. Like, I need to find someone. If I can't find anyone else who knows it, that doesn't know the first source, like, I need to verify the information by two people who don't know each other. Or I need to take the source's information and run it down. And, like, I have to be able to be like, did you make a mistake? Did you get it wrong? Like, you've raised serious concerns for me. I have to be able to say that. That doesn't mean that, like, I'm acting with malice. It's the opposite. Like, if I were obsequious, I'd be like, oh, yeah, I don't care at all. You know, like, dude, you lied? That's cool. Like, I just want the story. Just give me the story. I don't care that you lied. I wouldn't even question it. So the whole thing is just ridiculous. I'm sorry. I can't agree with this ruling. Not only do I think one of the most important citations was hallucinated, I think the crux of this ruling completely degrades the point of the actual malice standard, which is designed to protect the public sphere. So how's that for an analysis? I am a towel. Hello, Sarah B. Creative. It's so good to see you all. Listen, you all made it 5 hours late into the night on a Friday doing shepherdizing and studying the standard, the enumerated standard under the case law for actual malice. I'm incredibly impressed. You should give yourself a pat on the back. T.A. Sarah gets 5 trillion Googleplexes worth of bonus points. So does Bunny. So does Bo and Bo's mom, who we're praying for. And Kofi and everyone in chat. So that's a lot of bonus points. You all will probably pass the final. Even Kevin from South Boston, who speaks Spanish now. All right, let me get Peep. Francine's not here, but she'll watch this later. She likes to see her friend Peep. Now, you may have heard that Peep has been around. He actually came on a little trip with me. All right, he's with me though. This is Peep. All right, say hi to Peep. He's Peep. All right, he's Peep. He's great. I hope you all are doing well. He wanted to say hello. He's a Peep. He's the channel mascot. Now, if you had a good time today, Sarah Creative, TA Sarah, Kevin from South Boston, user, it was so good to see you and all of you. Do you think any lawyer posing as judge could be worse than Canoni? It's like Judge G is jumping the shark. Yeah, I think Judge Gildea just, he might be good at certain cases. I don't doubt it. Like, he's a good judge, I'm sure, like in his area of expertise, but he's not a judge for this case. Like, I have to be very direct about that. Like, we need a judge who can do this. This is a very serious case with important consequences, and I don't think he can do this. I'm sorry, I just don't think he can do it. And we need someone who can. I don't know what the court's going to do. I want to hear what Attorney Little has to say about Ducey. It's going to take her probably like 40 minutes to get through it. It's only like 23 pages, but it's dense. And like, you have to think about all the cases we thought about, and then you have to realize like what Ducey, first of all, you have to realize Ducey doesn't stand for what, like, it's the opposite of what Judge Gildea wants it to stand for. And then you have to realize like where the quote comes out of, and then you have to look at the cases we looked at. What do I say they are? Connaughton, St. Amant, Hunt vs. Liberty, Bose Corp, and McFarland. They're all summarized in Ducey, so you don't have to actually look at them. But if she comes to the conclusion I did, then yeah, forget about the ruling being appealed. We might have a hallucinated case citation in a judicial order. All right, my name is Grant Smith Ellis. One Best Gigi, thank you for being here. Interpret Towel. Oh no, you came right at the end. Yeah, we had a long day. This was the second 5-hour stream. I got to rest. So, if you've been here, if you enjoyed it, thanks so much. You know how to support if you've been around. We have a Discord, by the way. Come hang out with us anytime. I pop in there in the morning sometimes. Today was a long day, though, so I'm going to try to sleep, hang out with Towel Girlfriend tomorrow. You know, I heard a rumor. Here's a special reward. I heard a rumor that Towel Girlfriend might come onto stream and, interview me. Not like now, but she's a little bashful. She's so beautiful, though. Wait till you meet her. She's so cool. Oh, she just makes my heart sing. She's so smart. And she has the coolest accent. And she sings, okay? And she's so beautiful. It's almost stunning. I'm overwhelmed by her beauty. You know, she's just wonderful. So anyway, she would really like to she brought it up. I didn't bring it up. She would like to interview me on the channel. And then you could all meet her. And, I know a lot of people have either interacted with Towel Girlfriend in chat or talked to her on Discord or whatnot. She's wonderful. She's a lovely soul. And she's very smart. So it's very, erudite legal analysis, I imagine. But she's also, very interesting. So who knows what we'll talk about. But yeah, I don't know when that's going to happen. I'll talk to her about it. So yeah, that'll be fun. She is Interpret Towel. Isn't she just a gem? She's great. So, Chase, it was so good to see you. So, I'm so excited. One Best Gigi, it's wonderful. I feel bad. So, I don't feel bad, but sometimes, news will break when we were watching Pride and Prejudice with Keira Knightley yesterday. And inevitably, some ruling will come down or somebody will do something crazy. Oh, thank you, Ismael Mendoza. God bless you for those jewels. That sparkle was great. Inevitably, something will happen, like a court decision or a news development, and so I'll have to be okay, beautiful, I love you so much. I don't mean to do this. I have to go. And she's so understanding, and she loves to watch the stream, and I'm just so grateful. My life is dictated by the news cycle, so she we're not passing ships in the night. I set aside time to see her as much as possible. But during the week, it can be just constant news. So, I'll just be okay, we'll finish our Pride and Prejudice movie. We haven't been able to do that yet because the past 24 hours was rough. But I'm hoping to do that tomorrow with her. And then if you get to meet her, I think you'll love her. You've actually heard her sing before. I've played, she sang just acoustic. A version of a song, which was great. Young and Beautiful, I think she did a rendition of. Yeah, and she plays instruments, she just blows my mind. She kind of reminds me of, she's just my other half. I don't know how to explain it. She's just like, it's very yin and yang. She's very erudite, and then she also is very cultured, but also rebellious. But she also is more like effective with executive functioning, and she has high analytical reasoning and better emotional intelligence. So it just works. We have our own subject matter expertises. Like, she teaches me about things, like some stuff I just don't know. She's very smart. And then, like, I just say things to her, and I'm just blown away because she just follows what I'm saying. And I'm grateful for that. So I wake up every day just the happiest man. And I'm very grateful to God. And so, yeah, maybe you'll get to all meet her too, and I think it'll be great. Oh, God bless you, Chase and Donovan and Kevin from South Boston. Good night to you all. I did, Donovan. Hi, Phyllis. Phyllis says, hi, Peep. Grant, please correct the typo in your bottom banner. Safety net. Saftey. How does it spell now? Phyllis, I am so glad you caught that. I never would have seen it. Saftey. Saftey. All right. SAF. Hold on. SAFTEY. I think that's what it says, Phyllis. SAFTEY. If it doesn't, you let me know. But I think it actually says SAFTEY. God bless you all, though. I think we'll do our outro now. Shout out to Triple Bob. If you learned something today, if you benefited from today's stream, you know where the links are. You know how to find the Discord. Thank you for supporting me. Thank you for being you. I'm exhausted. 2 streams today. I'm very tired. SAFETY. SAFETY. Got it. Yeah, I'm not the best. I'm learning how to spell. T.A. Sarah's like, we're all learning today. You're so smart, T.A. Sarah. Hi, 3 Clerk Monty. How you doing? You made it as well. You all did so well. I'm so proud of you all today. SAFETY. All right. SAFETY. Fixed. Phyllis, I'm sure that has been pestering you for so long. Hello. I'm back. I was trying to say, Phyllis, I'm sure this has been bothering you. And it's fixed. I'm so grateful to you. I never would have noticed that. We're back now. It's fixed. Thanks to Phyllis. So yes, if you want to support Towel Stream, you know how to do it. I'm going to get some rest. So maybe you'll see me this weekend. Maybe you won't, depending on the news cycle. I'm tired. I'm a tired towel. I got things to do. Fascinating day of streams today. We'll see about that fundraiser for Towel as well. That'll be fun. Until then, be well. My name is Grant Smith Ellis. We'll do Tippecanoe and Tyler 2, then I'll get out of here. All right? We like to cite the presidents in order to test my mental acuity at the end of streams. All right? As a reminder, this public information service that I try to do is run by one person. It's designed to educate, inform, and entertain you. 20% entertainment, 40% education, 40% information, such as to engender, coach a public discourse, and ward off the usurpation of our forms of government worldwide. God bless you all. Thank you for being willing to learn. I'm so grateful to you. With that said, here's Tippecanoe and Tyler 2. President Washington, President Adams, President Jefferson, President Madison, President Monroe, President Adams Jr., President Jackson, President Van Buren, William Henry Harrison, I don't know, 10. 11 and 12 are Tippecanoe and Tyler 2, so that's going to be Polk and Taylor. Then it's going to be 13 is going to be Fillmore. And then it's going to be Pierce Buchanan, Lincoln Johnson, Grant, Rutherford B. Hayes, Garfield, Chester A. Arthur, Cleveland, Harrison, Cleveland, McKinley, Teddy Roosevelt, William Howard Taft, Woodrow Wilson, Harding, Coolidge, Hoover, FDR, Truman, Eisenhower, Kennedy, Johnson, Nixon, Ford, Carter, Reagan, Bush 1, Clinton, Bush 2, Obama, Trump, Biden, Trump. Oh, Phyllis, God bless you. Puppies are wonderful. Phyllis, so Phyllis liked puppies. I'm going to put a special emoji of Chloe the dog for Phyllis. God bless you, Phyllis. I do hate typos. You nailed it. I feel so much better now. I feel like a giant weight has been lifted off my shoulder. I'm not kidding, though. That would have pestered me forever if I had known it. So you're wonderful. That said, if you learned something today, if you want to pay it forward, if you found camaraderie in the chat, if you had fun reading intense court documents and learning all about the actual malice standard and otherwise, feel free, ladies and gentlemen, to consider paying it forward by doing a small act of service or kindness for those around you. Yes, you may consider a donation to our homeless vets or service members or their families. There should not be a single homeless veteran or service member in the United States of America. I can't speak for other countries against their will. Or we have failed as a society. What are we doing this all for if those who fought for our freedom are homeless on the streets? Consider a donation to help them today, ladies and gentlemen. God bless those human beings. Likewise, what if you would like to help our furry friends? This is Peep. He's not an animal, but he does love our furry friends. What if you want to help our service members and our animals? Well, have you considered a donation to animal shelters run by service members or veterans, or that help our service members or veterans? Great way to help our furry friends and our service members or vets at the same time. Now, what if you can't find such a charity? Have you considered a donation to an animal shelter in general or a charity? Great way to help our furry friends. They can't advocate for themselves. If you're in the UK, big shout out to the Big Issue, a way to help populations experiencing homelessness, sell newspapers over there, so you can help with a donation to the Big Issue. But it doesn't have to be a donation. It can be something as simple as smiling at someone on the street, reaching out to a friend or family member you haven't heard from in a while, or yes, even giving away 200 tomato plants like Francis Fruchel did one time and having them designated honorary towels during the outro forevermore. Yes, in that way, may we continue to pray the current realpolitik continues to shift from one centered on preserving, expanding, and demonstrating our power, to instead one centered on preserving, expanding, and demonstrating our capacity to engage in small acts of service and kindness rooted in unconditional love, therein allowing us to live up to our tau eudaimonia or summum bonum, our greatest good in the ancient Greek or Latin respectively, and in turn bringing about a new digital epic defined by Aquarius the water bearer standing tall and carrying a peep bunny towel. I believe it's possible because of you all. God bless you all. May God protect these United States of America. And as we come up on 10:30 p.m. Eastern Time here in Boston on this Friday, August 14th, 2026, it's 4:30 a.m. in South Africa, it's 5:30 a.m. in Tel Aviv, Israel, and it's 6 a.m. in Tehran, Iran, as the sun rises on another day, hopefully a peaceful day, in the Middle East, Saturday, August 15th, 2026. Good morning, good afternoon, good evening, whatever the case may be. My name is Grant Smith Ellis. Thank you for watching Towel News, youtube.com/@GrantSmithEllis. Until we see each other again, may God protect us all. Good night. God bless. And thank you for being you. I appreciate each and every one of you more than you know. Bye for now. God bless.